Committee Room 30, signed. 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 Committee Room 30, Committee Room 30. Signed. 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 Committee Room 30, 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 signed. Committee Room 30. 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 Signed. Committee Room 30, 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 Committee Room 30. Sound. 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 Committee Room 30. Sound.
Meeting of the Committee for Justice. The meeting is now open to the public. So we'll give them a chance to sit down while they're doing that. Obviously, as ever, the committee meeting is going to be recorded and broadcast throughout Parliament buildings and online. We're all welcome to use our mobiles provided they're in airplane mode and on silent. And I'll reiterate that for the folks coming in. While they're coming in, members, Doug is going to be late, and when he does join, he's going to be joining online. And we also have Stuart and Justin online. It's proposed that oral evidence sessions with departmental officials on the bill and the budget and the October monitoring round will be recorded by Hansard. Are members agreed? Thank you. Members, I would remind you that we're obliged to declare any financial interests or any other relevant interests which might reasonably be thought by others to influence our approach to matters under consideration. So, if anybody has anything to declare in relation to today's business, could you do so now or when the particular matter arises in the meeting? Does anybody have any interest to declare? Deirdre?
Yeah, immediate family works in the court service.
Thank you. Anybody else? And could I record that I have an immediate family member who works in the legal profession? I just want to flag up for members of the gallery. You're permitted to use mobile devices, everybody, provided that they're in airplane mode and on silent. Also, I would remind you not to take photographs or record any of the meeting. I can't imagine why for a second you would want to, but I'm obliged to let you know. Now, the next item on the agenda is apologies, and I have apologies from Sinead Ennis, and that's a full house. Apart from whenever Doug gets here, and he's already apologised that he may be late. Agenda item 2 is the draft minutes of the meeting held on the 19th of September, which are at pages 6 to 13 of the meeting pack. Are members content that the minutes are a true reflection of the proceedings of that meeting held on the 19th?
Content.
Yep. Thank you. And I'll sign the minutes. Agenda item 3 is matters arising, and I would refer members to pages 15 to 112 of the meeting pack and pages 3 to 100 of the table pack. At last week's meeting, Criminal Justice Inspection, their report on their inspection on the effectiveness of criminal court administration was mentioned, and that report was in the main body of our pack, but there were errors within that, so it's now part of the table pack. I presume you've all seen that. Are members content to note?
Yep.
Deirdre?
I was just on that to add, because I know what said about it was a media article in terms of the reports concerning we're going to do a visit to the court service, but I think it would be good if we could get a written update on what steps are being taken on the outcome of that report by the court service themselves in terms of some of the, I suppose, damning kind of indictment that was contained within it. So I'd be keen to get a written update in advance of doing that visit to the court service.
I think that's fair enough, plus that should give them a bit of time to work through the issues raised in it, and then they can give us something a bit more comprehensive. Members agreed? Agreed. Thank you. Agenda item 4 then is the Justice Bill, and we're going to have oral evidence from many people in the department. Thank you all very much for taking the time, and apologies that we kept you a moment or two outside. We just had a bit of housekeeping to do. So, officials from the department are here to brief us on the principles and content of the recently introduced Justice Bill. The one thing that I want to say to members is this. Please, if you have questions, take your time and ask them. We're about to have the second stage debate on Tuesday, so if there are things you want to know, now is your chance. Don't feel under pressure. Ask the questions. I would propose that in handling this, we just work our way through. So if there are general and financial questions and questions on parts 1 to 3, so that is the biometrics, the children's bail and custody and live links, we deal with those first. And then we move to part 4, which is the access to justice. So we'll take each section at a time, and I'll make it clear which section we're going to deal with. Are members content with that approach? Okay, thank you. Also, members, you should note that there are too many officials to be seated at the table at once. So after the opening remarks and potentially throughout the session, officials will need to swap places with colleagues in the public gallery when necessary, so that those with knowledge of particular parts of the bill can come forward. So could I welcome to the meeting, please, departmental officials Maura Campbell, who is the senior sponsor of the bill, Andrew Laverty, the bill manager. This is like the Price is Right, come on down, isn't it? The bill manager, Andrew Laverty, Lisa Bowl from the Reducing Offending Division, Veronica Holland, Deputy Director of the Rehabilitation and Reducing Reoffending Directorate, Therese Murphy from the Policing, HR and Pensions Division, Emma Crozier, Head of the Violence Against the Person Branch, Stephen Allison, Head of the Enabling Access to Justice Division, Patricia Kerr, Access NI, and Claire Irvine from the Civil Justice and Judicial Policy Division. Folks, you're all very welcome, and thank you. I'm going to hand over to you to give your initial presentation, and then, as I said, if you're also content, I think we'll work through each part at a time, so that we're a bit more structured rather than jumping from part to part. So many of you we know, those that we don't, thank you for taking the time. You're very welcome, and hopefully you'll enjoy your time with the committee today. Thank you, and I'll hand over to you.
Thank you very much, Chair. Good afternoon, and we're grateful for the opportunity to brief the committee today on the principles and content of the Justice Bill. As you say, I'm the senior sponsor for the bill, and Andy beside me is the bill manager, but because the content is so wide-ranging, we are joined today by a number of colleagues who are the policy leads for the various provisions, and thank you very much for working with us to structure it in such a way that we can hear from everyone. I don't intend to speak for very long at the start, because we're aware you will have plenty of questions for us, and we want to ensure we can cover as many of those as humanly possible within the time available. The Justice Bill, as now drafted and introduced, has 4 key principles, which are to amend retention periods for biometric material, to make changes to bail and custody arrangements for children and young people, to improve services for victims and witnesses, and to improve the efficiency and effectiveness of aspects of the justice system. Part 1 of the bill provides for the development of a framework for the retention of biometric material, including DNA and fingerprints, so that such material will no longer be kept indefinitely and will be subject to review. This part also allows for the appointment of a new commissioner to oversee the framework and the review process, and the changes respond to rulings by the European Court of Human Rights and seek to strike a careful balance between protecting an individual's right to privacy on the one hand, and on the other protecting the public through making effective use of biometric material in the prevention and detection of crime. This is a very complex and technical area, and I should make members aware that a need has already been identified to make some amendments to this part of the bill during its passage to ensure the provisions operate as intended, and we're happy to say more about that if you wish. Part 2 makes changes to existing legislation around bail, remand and custody for children with a view to enhancing compliance with the United Nations Convention on the Rights of the Child. It strengthens the existing presumption of bail for children by introducing unconditional bail as standard and requiring that any conditions that are applied should be proportionate and necessary. It also introduces specific conditions which must be met before a child can be remanded into custody. Finally, it places in statute the current arrangements for separating children and adults in custodial settings. Part 3 concerns the use of live links for police detention and interviews so that these can be dealt with more swiftly and efficiently, and these would bring Northern Ireland into line with existing practice in England and Wales. Part 4 contains a raft of changes relating to policing, criminal proceedings, legal aid, criminal records certificates and court security. And I don't plan to go into detail on each of those now, but there is a brief overview of all of those provisions in the written briefing and further detail available in the explanatory and financial memorandum. So that is just a very quick run through the content of the bill on introduction, and in addition to the provisions you have before you, members will be aware that we do plan to bring forward a number of additions to the bill, and these include provisions for the wider use of live links in courts and tribunals, to modernise and reform rehabilitation periods, to restart the accreditation process for organisations wishing to deliver restorative justice services, to repeal outdated vagrancy laws, to streamline arrangements for maintaining the list of offences that can't be filtered from disclosure certificates by Access NI, and to tackle those who direct or participate in serious organised crime. And while it's not unusual in this department to bring forward additional content during the passage of large mixed content bills, we do understand and appreciate members' concerns. And so we're still aiming to give you sight of the proposed amendments as soon as possible, rather than waiting until we're closer to consideration stage. We said in the written briefing that we anticipate all draft texts being available by the end of the calendar year, but the drafting of some of the amendments is now at an advanced stage. And so if the committee is content to take receipt of the amendments in tranches, we should be in a position to start sharing new content with you very soon. So I was going to pause there, and we're now happy to take any questions. Thank you.
Thank you very much, Maura. I suppose the first thing I want to say is, obviously you guys have been working on this for a considerable period of time. We have not. We are not as au fait as you, and we're still working our way through this. So if we raise issues which may be included in there, so you'll need to bear with us, because I think it's really important that we understand the principles and what this bill is aiming to do, and seek clarification where we need to. And if those questions perhaps appear unnecessary to you, remember that you're much more experienced in this than we are, and we're coming to this from last Tuesday, so we will need some time. Okay, I'm going to open the floor. Does anybody have questions, any general questions first of all? Morris?
There's just one. The amendments that you bring in later on, will they cross-reference some of the work that we've already have done on parts 1, 2, 3, 4, 5?
I don't really think they would. No.
There's no direct crossover. There's with the exception of the Access NI disclosure provisions in Part 4 of the bill. One of the amendments also involves Access NI's management of a scheme which allows old and minor convictions to be filtered from criminal record checks. So there's a common policy area there, but it's not directly linked to the earlier provisions in the bill. And similarly, the live link provisions in Part 3 of the bill, those are directly related to police interview and custody provisions, and the live link provisions that we're intending to bring forward as amendments, those are for the wider use of live links in more criminal and tribunal settings. So same framework of infrastructure, but for different purposes.
Yeah, so it's courts and tribunals, including both criminal and civil business.
Yes.
So, according to your answer there, there'll be minimal duplication.
Shouldn't be any direct
Oh,
duplication.
Right. The other thing through you, Chair, is the length of time that we will have to scrutinise amendments when they come forward. Will it be enough time for us to do our job effectively?
Certainly our intention that, without wishing to preempt or anticipate the length of time that committee stage might run, with the benefit of some experience of previous justice bills, committee stages tend to be quite lengthy, and we would hope that we would be in a position to be sharing the majority of the text with you in a number of weeks rather than months. And given that I would imagine committee stage is likely to run quite far into next year, we would hope that you would have ample opportunity to scrutinise them.
Thank you very much. Thank you, Chair.
You, Deirdre?
Yeah, just following on from that, and thanks very much. I mean, this is a sizable bill, including the addendums that are going to come later. And I don't want it just being taken that because we're going to take time to consider this, particularly on the back of the court case in terms of the judicial review and the human rights implications, even more so in terms of our scrutiny rule. But I don't want that to be seen by the department that, you know, you can take your time and bring in the other 6 areas. So I would be keen. I mean, we'd met before the summer and said that it would be ready in autumn. We're now being told that it could be potentially at Christmas time. Could that push out into January? So I would be keen to see from the department, particularly those 6 areas that would be brought at consideration stage. If that is a few weeks, can you confirm that? And in terms of setting out under each of the 6 areas, will they all be coming forward? And what will be available and when? So like a timetable of when that's going to be available. Because as the Chair said, you have had time to go through this. Even though we will take a bit longer as a committee, we still don't have that much time, and we want to make sure that the mistakes of the last legislation are not repeated this time, because it's too serious, and particularly the issues that are contained within this bill. So we would be keen to give it the proper scrutiny. So I'd be keen to get a timetable of those addendums and when, you know, they are likely to come. And as much of the information that can be given at this point for that to be forthcoming, rather than waiting and putting it all in at once.
Yeah, and I think when we spoke with you previously, we were planning on the basis of potentially a June introduction of the bill. We've introduced in September, so up until the point of introduction, the focus was very much on the bill on introduction and preparing for that. But Office of Legislative Counsel have been working really well with us in terms of trying to get the amendments drafted as swiftly as possible. If it assists, we could maybe sort of give some indication of the order in which we think they may be coming to you, and a sort of a rough indication at this point, or we could follow up in writing.
I think if it could come in, I mean, if you want to give it now, but if it can come in writing, because obviously the 30-day countdown is going to start on Tuesday when the second reading comes, for us to consider how much time we're going to give. So I would like to have as much of that as a committee, so that that will determine then what length of time the bill's going to take. So that would be useful. Yeah, thank you.
Yeah, I was going to say, if you want to run through that sequence, I think committee might find this helpful, because we've obviously been doing quite a bit of modelling around the timetable for the bill, and it's changed considerably since the bill was conceived as a concept. So, more if you wanted to speak to that issue.
I think the areas that are probably most advanced at the moment, and you know, we've seen clauses, and it's just a bit of finessing, I think, at this stage, and final queries have been addressed, would be the rehabilitation of offenders provisions, which I know the committee were keen to have sight of, and the community-based restorative justice provisions, I think, will be ready very soon, we hope. And I know that final queries have been addressed now on the biometrics amendments. But that's just sort of a finessing of the content we already have before you.
Sorry, biometrics.
Is it?
So just to, if I may just interrupt a second. So in response to Morris's question, it was indicated that there were amendments being brought on 2 areas, but now you're also telling us you're bringing us amendments on biometrics.
I did say in my open remarks, Chair, that we had identified a need for some amendments on the biometrics provisions, and sorry, we should have said when you asked that question. I think we had in our mind the additional policy content, but yes, the amendments to the biometrics provisions will relate to the provisions that are currently in the bill on introduction. I should have clarified that.
Essentially, we've had this bill, 9 days, and already there are amendments.
Lisa can talk to the detail of the need for the amendments, but it came from the department stress testing the provisions with operational partners when the bill was completed, when drafting was considered complete. And it's only whenever, as I'm sure you'll understand, when you start to go through the minutiae of the information yourself, that given the breadth of the biometric provisions, there were some issues where I won't pretend to understand them, but Lisa can talk to the detail of them, that it became clear policy intent hasn't changed, and it's not that significant new policy content is being added. It's simply, and I'm sure whenever you look at the bill and you see how many pages the biometric provisions extend to, the amendments are designed to ensure that those provisions operate as intended, rather than it being seeking to change the legislation as it's presented to you. It's not a change of approach.
No, I think we understand that, Andrea, and doubtless we'll come back to this issue, and I don't want to interrupt other members' flow of questioning.
Sure.
But I do think the committee expressed grave concern to the department about holding this bill until you were ready. But the bill has been brought, we've had it for 9 days, and now it's changing already. And our view has always been, let's do this, let's take the time to get it right, particularly in the aftermath of what is a very damning judgment of the department, the committee and the Assembly as a whole. So it is disappointing, to say the least, and we warned of this and we cautioned not to bring it until the department was ready. And I think we're seeing examples already now on hearing this that it's not, and that's concerning. Nevertheless, we will proceed in as constructive a manner as possible, but please proceed.
Well, I think the three additional policy content areas that Maurice just summarised, our expectation is that those should be available to be shared with the committee by the end of October.
That's rehab of offenders, restorative justice and biometrics at the end of October?
Yes.
And do you have a time frame for any of the rest, as Deirdre was asking?
I think after that, the filtering provisions are probably the next ones that you're likely to receive.
Filtering?
So that's the
Sexual
streamlining of the undisclosure of criminal records information. After that, possibly the serious organised crime provisions, followed by live links and vagrancy. Bit more difficult to predict precisely what the order of those later ones will be, but I think some of those we would hope would be available by November.
Yeah, certainly we would hope that the filtering and the serious organised crime provisions would be capable of being shared in November. The live links is the single biggest set of instructions that we've prepared. They're 138 pages long and have issued to OLC. So they and the repeal of the vagrancy legislation, we imagine that drafting of those is going to take a bit more time, and those are the two that we expect are going to take until the end of the calendar year. But we
would have thought.
Well,
That's 138 pages, okay.
A lot of plates spinning at the same time, Chair.
Indeed, at least you're being upfront about it.
138 pages minus attachments. It's significant.
Yes, it seems as if that would almost merit a bill in itself. Okay, Deirdre, apologies, I interrupted you there. Carry on.
No, it's if we can get that in writing, that would be good as well. Thank
We're
you.
happy to keep the committee updated if there are changes to that.
Thank you.
Deirdre, do you have anything else?
Not at the moment.
I'm going to move through the list then. Justin?
Thanks, Chair. Thanks, folks, for your evidence thus far. We've been told that this committee, that this is the largest and most complex bill coming before the Assembly in this mandate, and it's been touched on already, but how confident are you all about the ability of legislators to properly scrutinise this bill on its passage and the proposed timeline for its passage through the Assembly?
Well, I think the department won't be prescribing how long the committee will have to scrutinise the bill. Obviously, that will be a matter for the committee. Certainly, we expect the committee to take the time it feels it needs to properly scrutinise the provisions. And to be honest, we welcome that scrutiny because we want the legislation to be future-proof. We don't want to be having to come back to you in a year or two seeking to revisit any of those policy areas. And we are very happy to work with the committee in any way you'd like us to to facilitate that scrutiny.
If I might add, Chair and Mr McNulty, we were very conscious after the last mandate that we progressed a lot of information in an even shortened period of time than we have in this mandate. We carried out a lessons learned exercise with previous committee, and as part of the lessons learned for this mandate, working with the Office of Legislative Counsel and with TEO, Legislative Programme Board, we've limited ourselves to bringing forward one bill per calendar year of this mandate. So this is a big bill, but it's by no means the biggest justice bill that we've brought before, and I wouldn't necessarily say that it's likely to be the most complex, because the sentencing bill, which is due to follow this bill, is going to require some careful scrutiny as well. But conscious of that, we've sought to limit the department's aims for this mandate to one bill per calendar year or assembly year.
Thank you. Justin, do you have anything else?
Yeah, the explanatory and financial memorandum notes that the bill as a whole will be delivered primarily within existing resources, with some areas requiring approvals. What does this look like within the extremely challenging budget settlement department and organisations such as the police have received, and with a specific focus on the victims' experience and their trust in the justice system? How do you see that being impacted by the passage of this bill and by it being legislated for, and the resources available to actually implement the outworkings of this bill?
I think it'll depend per policy area, and I know that different policy leads will have been engaging with stakeholders just about the potential impact and consequences of the bill. But it might be better as people come to the table, or maybe colleagues who are at the table at the moment might want to say something about their particular provisions. There are a number of provisions, I think, of the bill that won't have particular cost implications. There are a few that do, but maybe if I could ask Veronica and Lisa maybe to speak to their
Certainly
aspects.
in terms of the bail on remand provisions, there aren't material costs associated with that. There are some relatively small technical changes that are needed in relation to IT changes. The cost associated with that is it's a few £1,000s, so there aren't material costs associated with those provisions being brought forward, and I suppose a lot of those changes will be to current processes and how things are currently working, as opposed to substantially new expenditure being needed in relation to the relevant organisations.
With regards to live links, we expect that will be able to be done from within existing resources using IT and infrastructure PSNI already has in place. In addition to biometrics, there will be a cost involved in setting up the Office of the Biometrics Commissioner, and we'll be working through that as part of our normal budgeting process. And in terms of the PSNI costs for implementing that, I know that there'll be resource implications in terms of software and systems that they need to put in place to be able to support that. I know that police are still working their way through that, and we're at the early stages of having those conversations with them around implementation and the planning and systems and costs that will have. So that's something that we will be working through.
If I could just add, and again, Chair, and for Mr McNulty's benefit, we've had an approach from the Assembly's Research and Information Service, people who've posed a number of questions to us around specific financial aspects of the bill. So we've responded with quite some detail to those questions, and I expect that that's something that you've commissioned from raised people. So we're happy to have already provided that information, and if there's anything further, particularly around the financial aspects that we can assist with, we're more than happy to share that detail.
Andrea, I don't know if we have as yet the document to which you refer, but the stuff that we have around finances at this point is fairly scant. Justin, do you want to come in again, or are you finished?
Yeah. One more question for this
Yes,
group. I'm
go
not sure
ahead.
if it should be directed towards this part of the meeting, but why are the Henry VIII powers included, clause 31, and what is the justification for their inclusion? How does the department anticipate that these powers will be used?
Where does that in?
Henry VIII powers are generally referred to as powers in, I think it's clause 30 or 31 of the bill. Clause 31, there's further provision there. these powers are much more limited than they would have been in the past. It's a power that has been taken in justice bills that allows the department to make remedial amendment to primary legislation by secondary, if and when it becomes apparent that there's been an issue in the drafting, or there's an error in the drafting, or an unintended consequence of some of the provisions of this bill on another piece of legislation. Now, it wasn't the last committee, I think it was the committee before that, in 2014. There was a particular focus on the continued use of these powers, so they are limited to the bare minimum, which allows the department to fix any issue with this legislation if it becomes apparent. It's not an overarching power which grants the department the power to do anything it so wishes. And in keeping with working in the devolved frame, any of the legislation that would be brought forward under Clause 31 requires Assembly debate, so it's affirmative resolution, secondary legislation. So the committee and the floor of the Assembly, other Assembly members would have their opportunity to consider and comment on any such proposals.
Justin, was that you?
Yeah, thanks, Chair. Thanks, folks.
Okay, I have Ciara.
Just two questions, just one following on from Justin. So can you explain what are the compelling reasons for Clause 31 and using the Henry VIII powers?
Well, I'm a man of a certain age and my memory's not exactly what it was. So if it pleases the committee, we can certainly set out in writing what the intention, what the background to those describing them as Henry VIII actually gives them more of a sense of importance than they actually carry any longer, but we'll certainly set that out in more detail for you, and we'll do that in writing.
Well, thank you. A practical example, we're carrying provision in this bill to rectify something that was spotted, that was a technical tweak needed to legislation from 2002, because there wasn't provision in regulation to address that, so we're having to use primary. I suppose it's intended ultimately to make better effective use of parliamentary time.
Assembly's time.
So if it's a small technical change, there's a quicker and easier way to address it rather than having to come back and seek further primary provision.
It's just from the information we have received so far. It can only be used in compelling reasons. Yes. So it's just to get clarity on that now. But thank you, and we'll appreciate the written. And just secondly, what plans exist for further engagement on the current provisions within the bill and the future or later amendments that we've just previously discussed there?
Engagement with
people?
With stakeholders? Well, I mean, each of the amendment areas have been subject to public consultation exercises, with the possible exception of vagrancy, which is being considered at the moment. There's a progress of ongoing engagement with key stakeholders around both when policy is being developed, when it's being finalised, and when it's being turned into legislation. So the committees under the Assembly route, the committee's call for evidence is then the opportunity for stakeholders and members of the public to come forward with any further current concerns or considerations that they would like the committee to address on the department's final policy position as reflected in the legislation. But it's not to say that we're not available to stakeholders or that we're not open to workshops or anything like that might help them with any concerns or uncertainties that they have with the legislation. There's nothing proactively planned, but we don't consider it a closed document, that there's no opportunity for further changes to be made.
So there is no further engagement from what's outlined in our paper of what the engagement to date?
Well, I can only speak in terms of...
But you'd mentioned then it's ongoing, so it would be useful what has been the ongoing engagement?
I'm sorry, I'm perhaps confusing things. Yeah. I'm talking about an overarching in an overarching sense on the bill as a consolidated piece,
Right.
but each policy area has ongoing stakeholder engagement with key stakeholders and operational partners. That doesn't stop once the legislation's drafted and included in the bill.
Maybe by way of example, for example on biometrics, we have if the bill is approved by the Assembly, there'll be various pieces of subordinate legislation that we'll have to put in place to give effect to various parts of the legislative framework. So we'll be consulting on the various sets of regulations that we have to bring forward, and updates to PACE codes will be required for the biometrics and live links, and again there'll be consultation and all of that, and we're continuing to engage with stakeholders as we work through the detail of the subordinate legislation.
Is there any areas that you feel, if you've had more time, there could be further engagement on it? Because I'm just conscious of dates. The DNA and biometrics, like it was 8 weeks of a public consultation, closed in August 2020, and we're now moving in the late 24-25, which is 4 or 5 years later. So that's just one example of.
Of course, that's not the only problem with that one. It was an 8-week consultation rather than a 12-week one. It was done in July and August, and it was done in the summer of COVID.
So that's what I'm trying to. Is there any plans at all across all the provisions within this bill to do intensive, up-to-date consultation with stakeholders as we go through the process?
We will.
I know we will, but as a department?
Because Andy says different policy areas will be looking at what's required for their own areas, but certainly in some areas like, for instance, live links in courts and tribunals, we've been engaging regularly with the likes of the Human Rights Commission and with the legal professions on those, and to be honest, other areas of the bill that they have an interest in. So, as we say, we're open to sort of continuing to discuss with people, but it's been more about clarifying how we are moving ahead following those consultations, and sort of giving maybe a bit more detail on the policy approach, as opposed to trying to revisit the overall policy in a lot of those areas.
And I think it's probably fair to say for a number of areas there continues to be engagement with stakeholders and interested parties more generally, as part of which there will typically be updates in terms of where the legislative provisions are at, you know, if there's anything that's been looked at further. So, for example, in relation to the young people's provisions, we had a meeting with a wide-ranging group of stakeholders not that overly long ago, at which there was ongoing discussion and engagement in terms of kind of where the provisions are at, what the next steps were, plans in relation to that. Nicky's also meeting the Minister next week, for example. So I think for a number of the policy areas, and I obviously can't speak for others, but there does continue to be engagement with stakeholders in terms of the work that's being taken forward more generally, as well as specifically in terms of the provisions that are in the bill, by way of update as to where progress on that is, or particular areas that they may be interested in going forward.
Yeah, and some stakeholders, it's mainly been wanting updates on sort of likely timelines for planning purposes. So, for instance, so that they can prepare for the committee's call for evidence.
I think it's fair to say that the ongoing lines of communication that we have with interested groups and operational partners, it's about wanting an update on where we are with the delivery of the legislation rather than wanting to revisit the policy approach. Now, I can say with fair degree of confidence that we haven't been approached by anyone to say that what's in the bill is flawed and that it shouldn't be progressed and that we should be revisiting and reconsulting on any of the provisions that are there at the moment. If that were to arise, it's certainly something the department would look at, but it's not the space that we're in.
Oh, thank you for that, and obviously we appreciate the ongoing engagements. So just finally, just to confirm, there will be no further public consultations on any?
So Andy did mention on vagrancy we are planning to consult. The reason we haven't done so already is that ordinarily you don't consult on straight repeals. It's if you're repealing because something has been replaced. We wanted to take a bit of time to look at whether we needed to make replacement provision, and the discussions on that has taken a bit longer than we'd anticipated. In the end, the Minister has decided that she doesn't consider there is a need to replace the legislation that's being repealed. So while, strictly speaking, I don't think there's a duty on us to consult on that, we feel that it would be prudent to do so. So we're planning to do it on a consultation later in the autumn. Thank you.
Do you want it in again?
Yeah, it's just on the back of that in terms of the consultation and engagement and feedback, but more around convention rights and whether they're compliant. So I know it says in the EFM that they are compliant, but obviously on the back of the High Court judgment where the EFM was criticised, as the Chair said, committee scrutiny was criticised on certain articles pertaining to the convention rights. Has there been a screening since you submitted this bill? And obviously the legal judgment was after that date. What additional screening has taken place around compliance with convention rights across all of this? Because from the data right through to live links, even in consultation responses, there have been concerns raised. And I suppose, is there an ongoing and structured engagement with the Human Rights Commission, and have they the resources to even respond to requests that Jews have made, or have they raised concerns around that as well? Because I know resourcing for the Commission themselves is an issue. So I just want to be satisfied how robust yous have been as a department on the back of that court judgment, even though the department was going to appeal it. But on the back of the court judgment, what additional screening work has been done around convention rights throughout the bill, and anything that's forthcoming. And also what has been the level of engagement with the Human Rights Commission with regard to these matters.
Thank you, Chair. I've actually met with the Commission quite recently. I can't remember the exact date, but we have been having ongoing engagement with them. We've had a couple of meetings just to keep them updated on where we are with the bill and the proposed content, and to have the opportunity to talk through in more depth some of the areas where there is a particular issue with balancing of rights. From the engagement to date, they're not sort of flagging a concern with me. I note what you're saying about the recent JR. We also, of course, now have the Court of Appeal judgment last Friday, which looked at the impact of the Windsor framework. Mm-hmm. So that is something we will be revisiting and looking at again, just to satisfy ourselves that in balancing rights in a number of areas across the bill, that we're satisfied there's no diminution of rights in line with what the court has currently said. Obviously it's a huge judgment. I think it took nearly 2 hours to read out in court. So bigger brains than mine are analysing that and making sure that we understand the ramifications of it. We're due to meet with council hopefully in the next week or two, just to talk through the implications of that legislation. So it is something we're very alert to, because as tends to be the case with justice legislation, very often you are talking about balancing competing rights. It's not an exact science. We do have to pay particular attention in terms of where rights could be impinged. So it is something that we do look at carefully as a matter of course, but just in light of recent legal judgments, we are looking particularly carefully at that.
Be keen if you have an update on that then, if a submission or something can be given back to us in terms of further work that needs to be done, or if you are satisfied yourselves with regards to that. And I suppose I'm also keen, because one of the criticisms in the JR was then, I suppose it fed into the consultation. There was a section of respondents left out whose human rights were implicated in terms of the last piece of legislation. So are we robust in terms of those that have been engaged? That there's no gaps in any of this piece of legislation that's gone through. And I suppose even with the biometrics, I know we'll get into it, it's an evolving space. So in terms of future proofing the legislation as well, or whatever addendums, I mean, you've already got addendums on the basis of some of the engagement that has been ongoing. So what will that potentially look like over the next period, and particularly around convention? I know as a committee we're going to look at additional legal opinion on this, but I would be keen once you have that assessment done, if that can be shared as well with the committee, that would be good. Thanks.
Okay, so that's my turn. I just want to pick up on a couple of things that have been said, and then I've got a couple of questions of my own. Andrew, you have indicated that, to your mind, the intention of the Henry VIII clauses would be to be to be used in a fairly narrow sense. However, the drafting of that actually would permit the department to take whatever powers it wanted. So I do think we have some concerns around that. What the intent is now may not be borne out in practice as we move, a number of years down the line. So I think that we would want to explore that further, and we'll await the verdict of the examiner of statutory rules on that one. With regard to the finances, I appreciate, Andrew, you've also outlined that there's a more detailed piece of work that has gone to raise that we have not yet received. The information that we do have is fairly scant, and a lot of it says, oh, well, we're costing this and we're moving through it and we're still working. And that's why it concerns me greatly that if a lot of this stuff hasn't been nailed down a bit further, how is the department able to say in the EFM that everything will be paid for from existing resources? Because on the one hand, after you leave today, we're getting a budgetary briefing from the department on, I suppose, the pressures and then the October monitoring round. And within that, I know that there's a memo to the Minister of Finance that indicates if there's not additional provision, then services will have to be cut. So it is difficult for me to understand how the EFM on this bill says we can pay for this with existing resources, whenever we already know you're actually not able, because of your financial pressure, you're not able to deliver what you're charged with doing already. And moreover, there's a memo going to the Minister of Finance to say we're going to have to look at service cuts. So I'd like you to address that, please. And the other thing I would like you to address is within the answers that we got around the financial effects of the bill, there is reference to subsequent business cases. For members, it's page 118 of our packs, and it's point 9. More specifically, it notes that some provisions will be the subject of individual costs and benefit analysis and subsequent business cases. I suppose, and again, the difficulty for that is at what point will those be made? At the point at which we've already passed the legislation. I'm not clear in the running order here in terms of horses and carts.
Yes.
But, I think we would like some reassurance around those issues.
When it comes to the department's legislative programme, there's an initial commissioning exercise where the legislation steering group that sits within DOJ seeks all of the department's directors to bid for inclusion of primary legislation needs for the mandate. Noting the time in the mandate, looking at the objectives in the programme for government, public statements that have been made around priorities, the legislation steering group will then start to work its way through the returns that they get to that commissioning exercise in order to create an initial programme with potential provisions grouped into what may be there'll generally be one mixed content justice bill per mandate, and then other bills would tend to try and maintain those as single topic bills or bills that are restricted to one or two discrete policy areas. In a mixed content bill like this, steering group secretariat approach all of the policy areas that have been provisionally included or provisionally identified for inclusion in the bill. They have to do a further detailed submission setting out the financial implications of their provisions, details of the screening exercises that have been carried out, details of whether there's been any negative or any details of objections or anything which has been considered particularly contentious around conversations with the committee or stakeholders or the media around the provision. So all of that information comes back again to the steering group so that the steering group can decide, okay, based on affordability, priority, on the grounds of the state of readiness, not just within the department but also in terms of future implementation. And I think that's where the distinction around some aspects of the financial elements can come in, because there's what can be delivered as a whole without any future monies. But then there's also discrete areas where the provisions of the bill create a framework which don't have a financial cost attached to them, but the implementation of the detail of the provisions, and if that includes secondary legislation and the setting up of bodies and whatnot, that's where the subsequent business cases needs to be looked at. And again, I'm good with legislation. I'm much less good with the details of the department's financial records, but there's a distinction then between what's considered to be a financial requirement for the delivery of the framework part of the bill, and subsequent implementation and subsequent secondary legislation, and then full implementation and operating costs after that.
Okay,
That's as simple an explanation as I can give, and I don't think it's particularly simple either.
Look, it's fine, but I do think, I mean, for the EFM to say, no, there aren't going to be, we're going to be able to manage this, honestly, I think it's a bit of a stretch.
I think,
because if you look at, within this bill, I appreciate what you're saying about secondary legislation, but within this bill, there's mention of a biometrics commissioner. That's not coming out of your existing resources. So look, there are areas around this that we'll want to probe further, doubtless as we progress through the bill and take evidence. We'll be hearing more on that. But, I think it's important for us as we approach second stage that we have some concept as to where you are in this and what you mean by it, and also put on the record a few of our bits and pieces. That's all I have in terms of general questions on finance. Members, time is marching on. I would propose to move into the biometrics section. So, without further ado, does anybody have any questions on the biometrics section?
Briefly,
Stephen.
Chair, thank you folks for the presentation. Just in terms of the 75, 50, 25-year model, is that something that is in use anywhere else globally, or is this bespoke to here? And then just with that in mind, what impact that could have, for example, on national security, at a UK level, for example?
The 75, 50, 25 isn't used anywhere else in the UK. Scotland, England and Wales have their own arrangements around retention. England and Wales still use indefinite retention.
Yeah.
Scotland's is slightly different. So this is something bespoke that we developed to suit Northern Ireland and based on the legal advice we received and what best practice was elsewhere, and taking account of the Sunita Mason review of criminal records. It was a proposal that we developed taking account of our legal advice in terms of how we best felt the legislation should address the findings of the Markburn and Cochran judgments.
You're confident that is the best fit for here, even though there's no hard evidence of it being used successfully
We
elsewhere?
believe so. We believe it's a step away from indefinite retention, which was one of the flaws raised in the European Court judgments. It's a step away from that, and it gives some sort of, we think it strikes the appropriate balance between the public interest in using biometrics to tackle crime and the balancing the rights to the individual. So we believe it's a good fit for here. In terms of the impact on national security, the taking and retention of biometric material under national security and terrorism legislation is responsibility of the Home Office. We don't have competence to legislate in that sphere. That's for Home Office.
Okay. Just one other question around the Commissioner was mentioned, the Chair mentioned it too. Scotland, was it 2021 they introduced their Commissioner? Has there been lessons learned from that? Do you feel any positive or negatives around that?
Yeah, we obviously took account. We're in regular contact with our Scottish counterparts, and we looked very carefully at their legislation in terms of the powers of the Commissioner and the role of the Commissioner has there, and the role of the Commissioner in England and Wales. And we feel that the model that we've struck and the changes that we made have taken account of that. We haven't exactly replicated the Scottish model. We've developed a model based on what the Scottish have done that we think suits the circumstances, suits the needs here.
Okay, and it is a good point. I think the Chair mentioned about the financing of that, is obviously going to be a key challenge, and we'll be keen to hear more about that going forward as well.
Yeah, we're happy to share that going forward. We're obviously looking at the business case on that in terms of estimated costs, and it's estimates at the minute in terms of the staff cost and what sort of a staffing model is going to be needed to support that Commissioner. So we'll be working through that with our finance colleagues in terms of the resource implications of that.
Okay, thank you. Thanks, Chair.
Thank you, Deirdre.
Yeah, no, thanks very much. I suppose I want to understand the thought process behind the 25, 50 and 75, how it's appropriate for here, so what that legal advice is and if that can be shared. So why that is appropriate here, but nowhere else across these islands use a similar kind of framework, and also have they been assessed against convention rights, and again has that work, that scoping been done, and again could we get a copy of that as well?
I don't think we have anything that we could, a copy of a document that we have that's readily available to share, because some of this was developed quite some time ago. I'm not sure what we would have on record, but as I say, we looked at the English and Wales model where they're using indefinite retention, and we I think the advice that we received at the time, and it was sometimes before I was in post, but I think the advice that we got back at the time was that that wouldn't be suitable in terms of the findings of the European Court judgment, and it was considered that we needed to move away from indefinite retention. Scotland's slightly different. Their legislation is silent in terms of retention periods. They have, Police Scotland operate their waiting policy where there's after a certain amount of time, the Police Scotland wait the records. There's nothing actually in the legislation, so they're slightly different. So we were kind of looking at examples of other regimes elsewhere, taking account of the legal advice in the judgment, and developing what we thought, taking account of as I say, of the Sidney Mason review, which was based on 100 years, but we sort of brought that down to look at the 75, 50, 25.
Okay. Sorry, there was one more. It was just around the where it had said that the bill doesn't necessarily clearly define biometric data, and I was just going to ask why not, and just in terms of obviously emergent technology and the kind of public interest argument for retention against Article 8 rights.
So in terms of the definition of biometrics, we've focused on fingerprints and DNA for the purposes of the legislation that we're putting forward, and I think that's consistent with England and Wales and Scotland, and I think that's probably focusing in terms of the biometrics that are most readily used in sort of police investigations, so it's focusing on those. It's an area that is evolving and changing, but I think the focus is still in place in terms on fingerprints and DNA, and obviously technology and all is another emerging area, and that's why we're giving the Commissioner a remit to provide advice and guidance on that to keep abreast as developments to take account of emerging technologies.
Sorry, just two on this was around, are you benchmarking with the south of Ireland as well? I can understand England, Scotland and Wales in terms of the synergy and the systems, but just the nature of the island as well, is there benchmarking happening with the south? And just in it, sorry, it's just where there's a number of databases that are used to hold biometric data, which are used by the police, so the DNA database, the local Northern Ireland DNA data. Is there any intersectionality between those databases? I know some of the more police ones there are, but between those, and do you see a role of a commissioner in terms of safeguards and oversights with how that data is used, particularly in an evolving technological space?
Yeah, the Commissioner will have an oversight of the whole legislative framework, including how biometrics are used, taken, retained, all of that. So the Commissioner will have an important and independent oversight role in all of that. And in terms of the intersection, colleagues in forensic science manage the Northern Ireland database, and are also they also link in then with the management of the national database. And there's a national DNA strategy board that forensics, police and the department now sits on, and that brings together police and departmental officials, the commissioners, information commissioner from right across the different UK jurisdictions to provide that overall sort of strategy and cohesion there. In terms of the Republic of Ireland, we haven't really done as much active benchmarking with the Republic as we have with England, Wales and with Scotland, probably because the jurisdictions are quite different, and I think the legislation in the Republic of Ireland is quite different. Yeah. But it is something that we can keep under review in terms of moving forward on technology and that sort of thing.
Okay, thank you.
Thanks, Deirdre. Ciara?
Just following on, what are the likely implications of different retention systems?
I don't think we don't envisage any difficulties or any different implications. We do, it will, in terms of the devolved legislation, we don't envisage any implications of having different rules in different countries. So the various systems that are in place will be able to handle, they'll be able to handle that will be able to be managed. We don't envisage any issues there. And as I say, national security, DNA taken under national security and counter-terror is managed by by Home Office, so we don't envisage any issues at this stage. But
would you envisage any administrative burdens being placed on police or?
Well, obviously the police at the minute they currently manage and have to administer and store and retain DNA, so that's something that they do already. There will be some changes and possibly some extra work by bringing in the review process. We haven't quite there might be some additional administrative work required there to process the review arrangements, but it is already part of the police's work to manage the retention of fingerprints and DNA.
Thank you. And just one final one, is that okay? What safeguards are in place to ensure that the data doesn't be retained inadvertently or unlawfully?
We've built in the review process so that after a certain number of years has passed, there will be a requirement on the police to carry out a review to see if they need to continue to retain the material or not. There's also provision for a person to write in to request a review of their material, and obviously we have the role of the Commissioner to provide that independent oversight, and that would be an important safeguard as well.
Thank you, Lisa.
Thank you very much, Ciara. Stuart? Stuart? Can't hear you. This might be a broadcasting issue, is it?
Apologies.
Oh,
okay. Yeah, broadcasting issue is actually quite poor today. Just in relation to the Biometric Commissioner, can I ask, what powers do you envisage the Commissioner having to deal with either breaches or recommendations? Will they just be recommendations, or will the Commissioner have a power to enact?
We envisage the Commissioner as having the power to direct the police to take certain actions. So if the Commissioner believes that they're holding material longer than necessary, they'll have the power to direct the police to delete that material.
Okay, but there are no further powers being planned for the Commissioner?
Not in an enforcement sense.
Where are you benchmarking those powers? What comparator are you using to benchmark those powers against?
We've been looking at the powers of the Scottish Commissioner and the Information Commissioner in terms of the powers they have and what would be appropriate.
Okay, so they will either match but not go beyond, for example, the powers of the Information Commissioner? No. Okay, thank you.
Thanks, Stuart. Doug, just for your benefit, the way we're pursuing this is that I've said to members, look, we've got second stage on Tuesday. Whatever you need to ask it now. And let's make the most of this opportunity. And the other thing is we're just working our way through the bill in parts. So we'll deal with each part at a time so that the questioning is a bit more structured. So just so that you know what we're doing. So at this point, we're in the middle of biometrics. Does anybody else have anything on biometrics? I've got a few things, if that's all right. I want to reiterate again, this is a subject that is difficult. It's emotive, it's technical. There are many other parts of legislation entwined in this. And I know that you'll have been working on it for a long time, but we haven't. We're also conscious that we're balancing, we're trying to find the balance between rights and the ability for people to get justice. So not an easy area, and that's why I do have concerns, and I want to put it on the record that was an 8-week consultation over a summer period during COVID. So, I think that's a flaw. Anyhow, we'll move on from that, but I think it's important, and you may want to address that and what you've done maybe to update in that period, but I think it's important that that's put on the record. There's a couple of things then. I'm going to run through a few questions and we'll take them a bit at a time. I'm just conscious of time. The information that we have indicates that the cut-off for retention of data with regard to legacy cases in GB is the 10th of April 1998, whereas here it's the 31st of October in 2013, and I would like to understand the distinction and why that would be. With regard to finances around this, when the query was asked around some of it, we were told it wouldn't be appropriate to share costings because they're still being worked on. But again, that takes us back to then, why would the EMF state that it's going to be done through existing resources? I appreciate this not in your work, but it attaches to this work around retention. Is the ICRIR time bound And if that work isn't complete, what is going to happen to their samples and exhibits? Around, it's page 53 for us, I think, around all biometrics, there's stuff around deleting after 10 years. My fear around some of this is that it could stop crimes being solved as technology improves. So we're already seeing in the States that a significant number of cold cases are being resolved because of genealogical DNA. So if we're going to future-proof all this, it would be helpful to have some understanding as to what categories of crime fall into which area, and what those kind of look like. You know, we have kind of broad brushes, but we don't know necessarily. And just on that same line, there's things that worry me about this, because there are people who don't have convictions around the retention of DNA on people who haven't been convicted. There are people who haven't been convicted, but it's a case of it may well be that the police haven't yet been able to match the sample as they work through. And just because somebody hasn't been convicted doesn't mean they're not guilty. And I would be concerned that justice opportunities would be lost because data has been lost. I mean, we know the police hold biometrics. We also know they have a raft of exhibits that haven't yet been examined because they haven't had cause to. So that is a fear that I have, and I'd like to know what consideration you gave to that. With regard to the custody pictures, we note that you don't include custody photographs there, and you're essentially relying on how the police operate and kind of police goodwill there and a direction. But why would that not be included for the sake of completeness? And I'll leave it there and come to a couple of others as we move through.
Do you want to take each of those in turn, Chair?
Please, thank you.
And appreciate that the last consultation was short. I wasn't in post at the time, but I expect it was probably just due to the pressures of trying to get legislation ready in time and taking account of COVID. We will be consulting further on various aspects of subordinate legislation that needs to be put in place, and we're continuing to engage with bodies like the Human Rights Commission at the moment, so that there are plans for further consultation in some of the more detailed aspects of the legislation, and that will be obviously allowing as much consultation time, as much time for consultation we will take as we can, and take account of things like holidays to reflect the points that you've made. In terms of the issues around ICRIR and legacy, that's and NIO are leading on all of that. So I don't know if they've considered what happens when the ICR comes to being wound up and what happens with that and all yet. I don't know if they've got that far in their thinking, but that is something that they're leading on. They own the legislation on that. So I don't really know what their thinking is on that.
Lisa, just on that though, I mean, if we move on this, they're likely to take account of the way in the direction in which we have moved, aren't they? So how we do choose to move on this could have a significant bearing on legacy cases going forward. Yes?
The NIO has put in place legislation to protect material for legacy investigations. So that material's protected by their legislation. So obviously we take account of that, and we have been keeping involved an eye to where that is, but we don't think that impacts in terms of what we do.
No, I'm just a bit concerned about what happens at the end of the RCRIR if they're not done. Mm-hmm. And I don't know if it is time bound or not, but if they're not done and it reverts back, I think the NIO will have work to do, but they'll look to see what we agreed. So that's why I think what we agree on this could have import for the future. Yeah. You know, yeah. Sorry, go ahead, Lisa.
We'll be having those conversations with the NIO as they come to us on that. Mm-hmm. In terms of the deletion after 10 years, I think that was in relation to after death, and we've changed the position on that. There's no longer the provision in the primary legislation around after death. The provisions that were looked at originally weren't going to be workable. So what we've done is, because we've got maximum retention periods, if someone does die, in terms of the review process that we're building in, that should come through the review process as the police are reviewing the person's record or whatever, just that a person's death will be able to be taken account of then to see if there's a need to continue to hold the material or not. And if someone does die, there'll be provision to enable next of kin to apply to the police to have their material deleted.
Yeah, but the principle still remains the same. My fear about that is somebody may well be dead, but it doesn't mean they didn't commit the crime, nor does it mean the police couldn't link them to it. So the opportunity could be lost.
Yeah, there is. We accept the fact that there is going to be a risk that if somebody has had the material taken and that they don't have a conviction, their material will have to be deleted. That's coming out of the way of coming out of the court judgments. But if somebody has been investigated for a particular offence and had their material taken and is still an active suspect in an ongoing case, the police will be able to continue to hold that material until the case and the investigation is complete.
An ongoing case or the ongoing case?
Any ongoing case. If any case that they've been investigated for.
Yeah, but that's kind of what my fear is, because that's going to preclude people getting access to justice in the end.
And that's the balance that we're trying to strike, because the nature of the Cochrane judgment was that it was inappropriate to continue to hold material for somebody who doesn't have a conviction. So if somebody's under investigation for an offence, that material can be held until the investigation's completed. But just because they've had the material taken once and they're not guilty, it won't be possible. And we appreciate the risk there, but that's the balance of rights that we're trying to strike in all of this.
I understand, and that's what we need to get our head around and kind of determine where we are as legislators on that, because that'll be some of the most contentious stuff, I would think. Yes, go ahead, Lisa. You were still going there.
Yeah. In terms then of the pictures or custody images, we took the view that custody images weren't really considered as biometrics. There's different views on that and different opinions on that in terms of photographs and images in themselves as biometrics. Scotland took a different approach, England and Wales taking a different approach. So I think and after considering that, we decided not to legislate for images at this stage, just to legislate for fingerprints and biometrics. And as has already been acknowledged, PSNI will apply similar retention periods to custody images as they do to fingerprints and DNA, and we considered that was the most appropriate way to move forward at this stage, given that photographs aren't considered as biometrics.
Okay. And about the disparity in the cut-off dates between GB and Northern Ireland?
To be honest, again, I think that's something that NIO are probably best placed to answer on. I think it's probably to do with, I think the 2013 date was around changes to legislation in England around the governing of biometrics and the introduction of the Protection of Freedom Act 2012. I'm not sure why they chose different cut-off dates between GB material and Northern Ireland material. I think that would be an issue for NIO to address. I wouldn't feel comfortable to explain their thinking on that.
No, you can't be all-knowing, that's fine, but it may be something I think we would wish to seek clarification on from the Northern Ireland office to understand why the disparity. Thank you, Lisa, for your answers so far.
Chair,
yes, Andre.
I wondered if I could come back to a couple of points and just to add a little bit of context to some of what Lisa had said. It might be worth letting members know that the biometric provisions as included in this bill were originally drafted for inclusion in the Justice Bill at the end of the last mandate. So where Lisa had said that there was a time pressure around consultation and drafting of the provisions, it's not that the time pressure was associated with their preparation for inclusion in this bill, it was because of the pressure of getting them drafted for the last bill. And a point around the financial aspects and the text in the EFM, which says that the provisions of the bill will primarily be met from within budgets. Were it not for the Commissioner provisions, which were new provisions that were added to the biometrics material between what was drafted for the 2021 bill and what's now included here, the provisions of this bill wouldn't attract any additional costs. Biometrics is almost by exception the only part that requires further future business case consideration.
Return to the trust, but we'll come to that.
Okay.
No,
you're teeing me up.
In fairness, that's fair enough. But I think we need to probe this because we need to understand. Of course. And you'll appreciate, I mean, in previous bills, I mean, in post scrutiny, and we've heard from stakeholders since, you know, things were passed in those bills, and actually those organisations had to absorb the costs. you know, when their own resources were scarce. And, you know, I'm referring primarily there to the PSNI. Now, great legislation in terms of Operation Encompass and so on, that does great things, but there's some significant cost there that wasn't probed at the time. So from this committee's point of view, we've taken on board the learning, and we're trying to make sure those mistakes aren't repeated. So this is why we're kind of working through this, and I'm grateful to you for taking the time, but I think it's important that we do have this engagement ahead of Tuesday. Deirdre, did you want that again?
I was just going to ask, Lisa, in case I missed it, because you'd said at the start there's going to be some more addendums to what we already have. In what areas, roughly, in terms of the biometrics that will be coming forward?
There'll be amendments. The existing legislation has powers that haven't been commenced yet to enable police to recall people to have their biometrics taken if they weren't taken while they were being questioned or whatever initially. So we wanted slightly tweak that power to give the police the time to specify a time and a date that they have to come back on. At the minute, it's just an open power to require them to come back, but we want to be able to give them time and a date so that it's easier all around for them to manage that process.
That's clear,
yeah, and to extend that to be able to recall them to take a photograph as well. We also have to, the term reported is used in the biometrics provisions, and we just need to change that slightly to when the complaint is being laid against a person, just to align about the appropriate stage that has to be just to clarify the timing on that and make sure that there's a consistent understanding of the term reported, because that has caused some confusion. And we also have to clarify the retention in light of the changes around community-based restorative justice. We have to just clarify the retention period for court-ordered CBRJs for adults. So it's just to clarify those.
Okay, thank you.
Sorry, I'm still going, folks. Just a couple more issues to raise. I want to check around repeat convictions and the impact on retention. Could one of you expand on that, please? Then there's, I'll run through them, Lisa, and then it means we can just...
Yeah, sure.
The other issue is around retrospective facial search for the PSNI. I know that there are rights issues around live kind of facial recognition, but retrospective, if you just touch on that. Also, in terms of children's data, it would be helpful to understand, and maybe it's something you can furnish us with as we move forward, what types of crimes for each category within that, because, look, I don't want to get dramatic about this. Northern Ireland hasn't really had many serial killers per se, but for example, there are things within children's convictions that indicate that are indicators for more serious offending going to come down the line. So if that retention is removed, you know, I think there would be an inability necessarily to match, you know, whereas somebody could be thwarted in their crimes more quickly were that to be retained. You know, I mean, we understand the whole business of people start off hurting animals, and move to hurting children, and then move on to much more serious crime, you know, and there are things that I suppose inspire that, you know, things that are indicators, bedwetting, head trauma, those kinds of things. So we know all the indicators. I'm not clear why we would be removing the potential to stop people before they were committing a series of very serious crimes, because there's a pathway in all of this. And the last one is the guards. And let me just get it up. It's page 79 on last week's pack. Yeah, there's also facial recognition technology about the guards. And there have been issues down there. Can I also check about how long they retain DNA? We don't know what the comparator is for how long the guards retain DNA, even in terms of legacy cases.
I don't know that. I would need to find that out, sure.
Okay, sorry. Right, Lisa, over to you.
Okay, in terms of repeat convictions then, so if somebody commits an offence and is sentenced, their material will be held for a certain number of years depending on the nature of the offence and whatever. If they repeat it, if they then go on to commit another offence, the retention period is recalculated, so it would go from to whatever the latest date is, would be the retention period for all the material that has been taken. So they're basically a repeat offence would mean your retention period is recalculated and it's held to whatever the latest date is. In terms of facial recognition and facial searching, we haven't legislated for that within these provisions. There'll be a role for obviously for the Commissioner in terms of providing guidance on all of that. I know the police are currently looking at what use they are going to make in terms of retrospective facial searching. I don't think there's any plans for the use of live facial recognition here at the moment, but I think the police are looking at their plans around retrospective facial imaging. I'm not quite sure where they're at with that. I just know that it's something that they're working on, but there will be a role for the Commissioner in terms of providing advice and guidance on that. And the Information Commissioner at the UK level has already put out a guidance note around the use of live facial recognition and the rights issues and all that need to be taken into account there. In terms of children's offending, the legislation does provide retention periods for offences whenever they're committed by children, and that's tailored in terms of those retention periods are shorter and again are determined by the nature of the offence and the nature of the disposal that they're given. So it is a tailored regime. It's not that children are being left out altogether, but we're trying to take a more proportionate approach for children, so we are trying to tailor that. But if there's more information that you would want on that, we're happy to provide that if we need to come back to you in terms of writing.
I suppose we'll know better what we need as we work through it, Lisa.
Yeah, I appreciate that. In terms of facial recognition and the use by the Gardaí, I'm not up to speed with the detail on how they use that and what their retention periods are. Again, I think that would be something we would need to find out more on. I don't have that information.
We can check that. We can use Ray's to check that. If our members agreed, we check those things with Ray's. Yeah. Thank you. And that's us covered. Lovely. Right, if we can move on then to children's bail and custody. Members, who's got stuff on this? No. I do, but you've heard from me long enough.
You start, Chair.
All right, I'll start. Okay. Let me see. I need to make sure because I'm using 2 packs here. I'm working through last week's pack too. Okay, page 126. Yeah, with regard to the children's stuff, we've got a memo that outlines essentially unconditional bail as standard for children. Now, that's not quite what the bill says, and I want to understand the distinction, because I must say the whole notion of unconditional bail, even for children, concerns me on a practical basis, because we know that bail conditions can be something as straightforward as you must reside at this address, you're not permitted into that area, and sometimes where children are concerned it's with regard to a curfew. We also know that for some parents it is useful, they welcome a curfew, they welcome such conditions because it enables them to control children and teenagers of whom they've lost control, and it helps them to keep them out of trouble. So I'd like some clarification around that, because what I don't want here is, I appreciate now that we're now referring to young adults as children, and I don't want it to appear as if we don't conceive, or the department doesn't conceive, that young adults and children can't cause mayhem from a fairly young age. They can in groups be considerably intimidating to elderly people and so on, and I think that these are things we can't lose sight of. I also understand we need to treat children differently, and we've got to be careful how we treat them, but we also need to consider victims of crime and the impact they can have. So I'd like you to touch on that. I would also like you to touch on, you've indicated that there aren't really this whole issue about bail and accommodation, and there's reference to bail fostering and the costs going to the trusts. I think that's a pilot at the minute, isn't it? I'd like to have some understanding, and I noticed that part of the pilot, bizarrely, wasn't about working this up and seeing the impact across how much it would cost across Northern Ireland, which seems strange to me. But any costs arising from that would be to the trusts. So what discussions have there been with the trust about taking that forward? With regard to this business about you can't keep a child in custody whenever there's nowhere else safe for them to go, I'd like some clarification around that. I understand. I mean, from what I can gather, this is a restatement of existing law, which is fair enough. But obviously, there are practical outworkings. I'd like to know what work has been done on the times and implications when social services have said they're not taking a child. Now, I appreciate that it's not a frequent occurrence. However, it does happen in examples where a child has become violent in a care setting, has potentially attacked other residents or members of staff, and social services are saying, no, we can't take that person, which means that the young person then ends up in a B&B or somewhere else, where again they could be subject to predators, and potentially then it could be safer for a child to be in custody. And by custody I mean in a youth justice centre rather than left in a B&B. So what thought was given to that? What work was done around those times when social services says we can't take that child? And I'll leave it there for now.
Thank you. In terms of that first query, Chair, in relation to the unconditional bail, so the provisions that are being brought forward are obviously providing a statutory right to bail rather than the presumption to bail which exists at present. Unconditional bail, as you note, is to be the standard approach that is adopted. That said, there is still provision that any bail conditions which needed to be considered in relation to that particular case, that those would be proportionate and necessary, and in particular taking account of the particular circumstances of the case. So it's a statutory right to bail. Unconditional bail would be deemed to be the standard approach, and if there are to be bail conditions imposed, those bail conditions should be proportionate and standard and reflect the particular circumstances in relation to that case.
And again, can I raise one other thing with you about this? I understand, I understand where you're coming from. I just think there are implications, and a standard right is okay, but the business of unconditional, I think, still needs to be looked at. And one of the issues in the bill you've down here, whether about the right to bail, and then unless it is satisfied, unless the court must not impose a condition of bail unless it is satisfied that it is necessary to do so to prevent, and at Part D it says the child's release causing a serious threat to public order. And where this concerns me is whether or not there is a serious threat to public order, either a child has a right to bail or it does not. And that provision has potential to allow communities to direct and dictate whether or not a child has a right to bail, and that's not right. The law dictates whether or not a child has a right to bail. And there, that could encourage communities to stir up opposition and prevent a child from getting bail when that child has a right, a lawful right to bail. So did you give consideration to that?
And that's something that would obviously have to be considered in terms of the particulars of that case. It's something that would be considered by the police, also by the prosecution service, in terms of whether any charges were to be levied against that individual. If it was court bail, that's then something that would be considered by the judiciary in terms of whether or not bail was to be granted and what any conditions associated with that bail may be. But I suppose the focus is trying to ensure that as far as possible, and taking account of the particular circumstances of the case, that bail is granted to those children. I think a factor that has obviously been important for us in terms of the considerations here are the number of individuals that are remanded into custody where there's not necessarily a custodial sentence at the end of that time period. So I suppose there's a range of factors that are being considered as part of that process, and about trying to ensure that it's proportionate, it's necessary, but that there is still that provision that if bail conditions are needed, given the particular circumstances of that case, that those can be brought forward.
The concern about that is that if somebody has a right to bail, even in terms of conditions, if they have a right to bail, that right is there regardless of public opinion and regardless of public order. If there's a public order issue, then one of the conditions should be you're not allowed in a given area. But it seems to me here you're creating a road. You're creating a road for people who, and it has potential to lead to overcharging. Is the other side of that. Anyway, I've raised that, and I suspect we'll tease more out on that and hear more about that. I'm going to open to members. I've taken enough time. Anybody else have anything on children's bail and custody? Deirdre.
It's just feeding into the custody and sentencing bit. So just where in terms of Clause 9, introducing the general principle that children will only be held in juvenile centres, so feeding across to the earlier discussion around pressures on the system, is there the capacity to do that within the system if there was a spike, for example, in terms of detention rates, that could be, or what oversight mechanisms would be put in place then to ensure that section,
I suppose in terms of the changes that are being brought forward generally in relation to the bill, not necessarily limited to that particular clause, is very much a desire that for young people they are held in juvenile justice centres such as Woodlands and Bangor, as opposed to being held in young offender centres such as Hydebank. So it's that separation of facilities between young people and adults. In terms of the capacity of the juvenile justice centre at the moment, their average number is 10 a day. I was down, had a visit at the Juvenile Justice Centre in Bangor earlier in the week. They are holding 10 individuals at the moment. Their capacity in relation to what they can hold is higher than that. So, and certainly I suppose the trend over recent years has very much been for a decline in the number of individuals that are being held in a custodial fashion, albeit that there is that wider issue in terms of individuals being held in custody where there's very little likelihood that they would go on to secure a custodial sentence. Certainly the sense I would have in terms of discussions that we've had with the Youth Justice Agency is I don't think there are concerns in terms of what their capacity is in terms of the number of individuals that are likely to be coming into custody versus what they're holding at present. That's not to say that there may not be something unprecedented, but I think certainly in terms of kind of the trend data, I think there certainly isn't any risk in terms of the numbers that they could potentially have in the centre versus what they hold at the moment.
Thank you.
Somebody else have anything to care?
Just to follow on, do we have timely statistics on, now you mentioned there's 10 at the moment and stuff, but things can quite rapidly change, as we know. Like, can be so uncertain. So is there access to timely statistics in relation to
There's
those?
information and data that would be held by the Youth Justice Agency in terms of the numbers that they have. So in terms of the most recent year, 23 to 24, they had 114 individuals remanded in custody. Of those, only 7 went on to serve a custodial sentence. There certainly is information available in relation to the statistics more generally, should you want to have that provided.
I would just want to know where that data is. Yeah, no, that's great. Thank you, Veronica.
Thank you. Can I just ask them, will you guys please come back to me on the issue around the conversations with the trusts about bail fostering?
And in terms of that bail fostering issue, so Chair, as you note, that's a pilot that's underway at the moment. My understanding is that there have been 2 successful placements in relation to that. It's in one specific trust area at the moment. Mm-hmm. My understanding is that there are to be further conversations and discussions in terms of how that could be taken forward more widely across Northern Ireland, but at the moment it is one specific trust area. There hasn't been an expansion out into other regions at this stage, but I think there is very much a desire to look at that further going forward and see whether or not that could make a beneficial and positive impact in terms of alternative accommodation that may be available for individuals. So it's certainly something that I think the Trust and Youth Justice are both keen to explore going forward on a wider basis.
So is there a time frame for that, Veronica?
I don't think so, and it's certainly not one that I'm aware of. We can certainly look into that for you, and in all likelihood I think that would be also subject to the necessary resources and the funding being in place for that. But I'm not aware of a time frame in terms of kind of the further considerations for the other court areas. Chair, you'd also asked about the issue of individuals being held in custody where there isn't a safe place for them, and obviously I appreciate that is a concern, and I suppose the issue in relation to Clause 8 more generally, where there isn't alternative accommodation available for those individuals. It's one of the reasons why that provision won't be commenced until there have been further discussions and outworkings in relation to that. I suppose in terms of some of the earlier discussions, there's also the fact that provision was a carryover from earlier legislation, and at that point I think there had been discussions ongoing in relation to shared secure care and justice campus. Those aren't progressing at the moment. albeit having said that, our understanding is from discussing with health colleagues that there are some discussions ongoing in relation to that, and I suppose that issue is likely to more generally be looked at in the context of the recommendations coming out from the review of children's social care services. But I think on that one we are very conscious that there needs to be a resolution in relation to that before those provisions could be commenced. I suppose we're also conscious of the fact that in terms of the provision of that accommodation, it's not within the gift of justice. It's something that would sit with the Department of Health, but there will be ongoing discussions in relation to that, and ahead of those provisions being commenced at a future point in time.
That's fair enough. I just think that it's an area in which we would wish to feed in, and I'm sure your department would wish to feed in, Deirdre.
Sorry, it was just another wee one around, I suppose, feeding on from the general principle of 18. So just obviously there was the 2023 report by the United Nations Committee on the Rights of the Child. So just do you feel that these changes meet all of the criticisms or concerns that were contained within that report in terms of the scope of this bill, and also then just the issues or implications around the minimum age of criminal responsibility, and if that was to change, are there any implications then in terms of this current piece of legislation that we're considering, and where that issue is as well? I would be keen to get an update.
Yeah. Obviously in terms of the wider issues, and I suppose the provisions that are being introduced are very much in response to the United Nations Convention in relation to the rights of the child, and a number of the provisions in that, the changes are very much intended to try and ensure that there is compliance with those, that children are only held in custody where necessary for the shortest appropriate period of time, etc., etc. In relation to the minimum age of criminal responsibility, you'll all know that it's an issue which the Minister would be very keen to progress. We recently prepared a paper and shared that with the Executive in relation to both that issue and also reasonable chastisement. As you can appreciate, the Minister would be very keen, as well as a wide range of voluntary sector and statutory organisations, to see that progressed. It's one that unfortunately she can't progress in her own right. Justice can't take a decision on that. There needs to be executive agreement in relation to that. We've only had one executive response to date in relation to that. So I suppose that's really where we're at in relation to that. The Minister would be keen to see change, but it's subject to the executive getting agreement on that. And I suppose in terms of the changes that are being brought forward in this bill, certainly in terms of the provisions that are included there, I suppose a number of those changes will mean that for less serious offences, 10 to 13-year-olds wouldn't necessarily be captured within that. There would be other mechanisms through which the offending behaviour or the incidents could be addressed, and I suppose something of a greater focus on 14 plus. So I don't see that if that change were brought forward in due course that it would necessarily have any adverse implications in terms of the provisions in this bill. Albeit very important, I suppose, to stress that it's not that those 10 to 13-year-olds couldn't be dealt with, that there wouldn't be redress. But I suppose try and really, as part of kind of the wider policy focus for the Minister, to try and ensure that those individuals are not necessarily going into custody for less serious offences, while also ensuring that there is the necessary provision to deal with those individuals through alternative means, and also to ensure that for serious offences, that custodial option still remains, so that there isn't any change in that respect.
Okay, thank you. And just the wee last snippet around the minimum age, would you have seen it sit within this bill or the next bill in terms of sentencing reform, or?
I suppose it could potentially sit in either. The issue, I suppose, is really the fact that there needs to be something in terms of executive agreement to that for the department to bring forward an amendment. Obviously, there wouldn't be anything to prevent individual members, as the bill passes through, to put forward an amendment in relation to this. And I suppose I'll just check with Andy whether that's right, my assumption that it could go in either.
I think certainly it could potentially fall within the scope of a justice bill if there were agreement to moving forward on a sentencing bill. I would be less certain if it would be within scope.
Thanks, Maura.
We would have to look at that.
Okay. So more so certainly probably this one?
Yeah, the conversations we've had with the Minister in the legislative programme, it's really this bill or none at all in this mandate. This would be the only bill which would clearly have the scope to capture it if there were to be a decision taken that something should be progressed.
Okay, no, that's useful. Thank you.
Although there are ways, I think there are clauses in this that indicate it's moving in that direction anyway. Can I ask you to comment on two things, please? The removal of custody care orders for 10 to 13-year-olds, and then what provision there is for 10 to 13-year-olds, because a lot of this stuff seems to start at 14, which makes me think the minimum age of criminal responsibility, you're moving towards 14, but maybe not just overtly.
In terms of that order that you refer to for the 10 to 13-year-olds, my understanding is that those provisions have never been brought into force. And I suppose the focus, again, as I'd indicated at the start, is very much, and in terms of the new order that's being brought forward, the focus of that is very much in terms of less serious offences. There's no change, I suppose, being made in relation to more serious offences. So your grave offences, if you have serious violent offences, serious sexual offences, there still is very much the capacity in relation to that age group. For custody to be brought forward in relation to that. So I suppose in terms of the committee concern, it's not that we were doing that. There is in no shape or form is it doing away with that option for that age group. It's just that the focus is very much on trying to ensure that custody is only where necessary, and the new order is really in terms of those less serious offences for that age group. So
the new order can be applied to that age group.
New order is 14 plus.
So what happens then on less serious offences for 10 to 13-year-olds?
That would be taken forward through a non-custodial route, so be it a community order or some other provision that would be at the disposal of the court in relation to that. It's not that there won't be redress, it's just very much trying to ensure that for that age group, we're trying to ensure that they aren't going into custodial environment for those less serious offences.
Okay, to check one other thing then. The removal of provision to place a child on remand for the purposes of obtaining information about them. How does that work? Has that been happening? I mean, what's behind this? What's going on there?
I suppose really in terms of that change, it's a provision that was on the statute book. I don't think that has necessarily been used to any great extent, if at all. But I suppose really again in terms of the focus of the provisions, the compliance with the UNCRC provisions to try and ensure that custody is basically being used appropriately, and it's not considered appropriate to be placing somebody in custody solely for the purpose of obtaining information from them, whatever that information may be.
That's fair enough. That's great, Veronica. Thank you. Okay, we're going to move to part 3, which is live links. Has anybody got anything on live links? Let's start. It would be helpful to see a summary of the consultations around that. I know some people were. We'll all agree the general principle of live links, but it would be helpful to see some information there, and whether or not consideration was given to case type rather than hearing type. Do you know what I mean by that?
So the legislation will provide for the use of live links for reviews of detention. So it's for the use for a function rather than by case.
Yes, but as you're moving into the policy area of police interviews,
yes,
and court appearances and so on, I appreciate that currently they're used for maybe some bail things and so on. But if it's hard because we don't have it in front of us. And there's obviously going to be 138 pages winging its way to us. That's in due course.
Sorry, that's probably confusing. I'm talking about
That's a different issue.
Can I just say, Chair, the fact that the instructions on live links for courts and tribunals run to 138 pages doesn't in any way suggest that the provision that is required in primary legislation is going to be anything near as extensive. To be honest, sometimes you have to go through a very lengthy and laborious thought process to end up with something quite straightforward and simple. So in policy terms, what we're seeking to do has ended up not dissimilar from the provisions currently in the temporary emergency legislation, but it's a good example of the issues that the Deputy Chair was raising earlier about the careful balancing of rights. In the past, we've been legislating on live links in court for about 20 years now, and that has evolved, and conclusions that were reached 20 years ago about where that balance lay, for instance, in terms of whether you need the consent of a defendant. I think back then, when the technology was at a different stage and there was less familiarity and availability of live links, a different conclusion would have been reached than we're reaching now. So just to reassure you, 138 pages just reflects how thorough and diligent we've been in working through those issues. It doesn't imply that we're going to create a massively long provision. Ultimately, obviously, it'll be for the draftsman how they want to present that. I can't preempt that, but I just want to give you some reassurance on that point.
The other thing I want to flag up to you is I understand what you're trying to do there and the safeguards that you're trying to put in place for children who aren't 18 and those who are vulnerable adults. But it seems to me the idea behind that is actually similar to the issues faced with body-worn video, because the police can rock up to those situations where there's a young person, or even for any adult, never mind a vulnerable adult, they're taking video footage that is used in the course of prosecutions, and as the police ask them questions about what's going on here, that's essentially giving a statement to the police. But it may well be that that person is vulnerable. It may well be that they're unfit for interview due to intoxication or whatever it's going to be. Was any consideration given to this? Because it seems to me the ideas are the same and the vulnerabilities are the same.
In terms of the Part 3 of the legislation and the use of live links for police interviews, will be, before the provisions are commenced, there's not much detail in the actual legislation itself around the use of live links, but what there will be consulted on two of the PACE codes, and they set out in a lot of detail the various safeguards and things that have to be put in place. So the police will have to take account of whether the use of a live link is appropriate, whether it enables the person to fully participate, whether they understand that what safeguards are put in place. So there will be a whole process that has to go through to, including the person getting legal advice and having and if they are a child, to have an appropriate adult there as well as their legal representative. So there will be a lot of checks and safeguards that have to be worked through before a decision is taken on whether or not the use of a live link is appropriate. And it may well be that the police have a child in front of them and might think a live link's not appropriate in this situation, we'll do it in person. So we'll be consulting on those codes in due course that will set all those safeguards out.
No, that much I get, Lisa. My issue is they're already doing this with body-worn video, but all the same risks apply without any safeguards. Same point.
So I'm not familiar with the position on body-worn video, but I'm just explaining that we'll be setting out safeguards around the use of live links.
No, that's fair enough, but I think the same issue is applying, but the same safeguards aren't in place for body-worn video. Okay, does anybody have anything else on live links? No? Ciara?
Just a couple. What cost is there to the PSNI in terms of training police officers in using the live links technology?
We've been in touch with police colleagues around implementation of this, and they haven't flagged to us any costs around training and use of live links, but I can certainly check and find that out. I'd say we're not expecting any, but I wouldn't feel confident in an answer for the police, so I would need to find out a bit more about that.
Okay, thank you. Will this apply to all categories of offence, the use of live links?
Yeah, it will be open to the police to decide to consider whether they want to use it. The offence won't necessarily matter. It will be on a case-by-case basis, depending on the individual that they're wanting to question or to do the review with, whatever they're wanting to use. It will depend on really the person, and whether it's suitable for use with that person.
And just finally, how will these new arrangements be monitored, and should they be subject to review following the introduction of them? And what's the plan?
The department doesn't normally monitor how the police conduct their operational business. The Chief Constable obviously has operational independence, but there are the existing oversight and monitoring arrangements in place through the Policing Board and their Human Rights Advisor, through Criminal Justice Inspection, through HMIC FRS. So those kind of existing oversight and monitoring arrangements are in place, and they would have oversight. And obviously there's independent custody visitors as well, so the department wouldn't necessarily do anything specific, because obviously we would respect the police's operational independence and also the independence of the existing oversight and monitoring bodies.
Just for our own information, it would be useful if we could get the police level of overview that they will have, or review process for the likes of live links. Once it goes live, it would be useful just to have that information, because it's like anything else that needs to be monitored and needs to be reviewed, so it'd be useful to know.
I'm not sure now what arrangements the police will put in place themselves, but we can certainly ask for detail on that.
That's great, thank you.
That's Karen. Okay, is everybody ready to move on to part 4, administration of justice? Do we need a change of table?
Make some personnel changes, Chair.
Just before we move on,
Folks, just a second. Morris got a question here. Go ahead, Morris.
maybe it's not in this section. The Northern Ireland Commissioner for the Retention of Biometric Material. This is a new post. Is it a full-time salaried annual post? Because in paragraph 5 it goes on to say about allowances, expenses to provide staff accommodation, equipment and other facilities. So what's the cost?
We're still working that out. We're still working through the process of working out what the final cost will be on that, because obviously we need to work out and obviously this will all be estimates at this stage until we see what the final shape of the office looks like. But we're working through the cost in terms of salary costs and what sort of budget might be needed to run the office.
Just for clarity, it's an annual salary.
We expect so.
And there'll be additional payments for staff, accommodation, equipment, I would imagine computers, etc., etc.
Well, there'll be obviously the cost for support staff in terms of the staff they need to support them in carrying out their duties. Things like accommodation and that type of thing, we'll be looking to see what can be provided from within shared services available across the service. So if there's DOJ accommodation, we'll be looking to see if there's existing accommodation there that they can use, and tapping in obviously to wider civil service resources for IT, HR, those sorts of functions.
Thank you very much. Thank you, Chair.
Thanks, Morris. Okay. Change of table, and now we've got Stuart. You wanted in part 4, didn't you?
Yes, Chair, thank you. I appreciate that being brought in at this stage. There are a number of areas in relation to this sort of part 4 of the legislation. The specific area, and if you maybe want to touch on some of the earlier parts, feel free to do so. The area that I particularly wanted to focus in on is the legal aid section. So, Chair, I'll take your guidance. If you want to do the earlier bits of part 4, please feel free. Otherwise, I'd like to ask a few questions around the legal aid.
No, Stuart, you do your thing now. We're just taking it part by part, so we're not being specific about where in the part.
Okay, Chair, thank you very much. Thank you to the officials for joining us. Chair, the 2016 Public Accounts Committee report on this subject raised concerns around the role of the taxing master, who adjudicates around some £19 million in legal aid fees each year. But that operation is outside public sector accountability. So can I ask maybe officials what specific steps have the department taken since that? And it's quite dated now, that 2016 Public Accounts Committee report. What specific steps the department have taken between now and these potential legislative changes to improve the transparency and ensure greater oversight of the process? Maybe some of the officials could actually give us some examples of the evidence of changes that have been made to address these concerns. I have a couple of other questions following that, Chair.
Mm-hmm.
Thank you, Chair. That's legally it falls to me in all those aspects. It's quite right to say the PAC recommendation has some vintage attached to it. There was quite a lot of work done after the PAC recommendation in terms of scoping how we could go about giving effect to the PAC recommendation. There was a project set up to look at the family fees, which is one of about 50 areas that is subject to taxation. Would it help if I explain what taxation is? Because sometimes when we mention taxation, it gets lost into sort of the vocabulary and lexicon of all things legal aid. Taxation is where the High Court or the Court of Appeal make an order for taxation where we don't have necessarily a legal aid framework, fee framework, and That order means that the solicitor and or the barristers will then submit their bill. The barristers will submit, the solicitors will submit a very detailed time and line fee into the taxing master, a judicial independent rule. The barristers will mark up a brief fee and send the brief fee in for assessment. The taxing master will then look at what's been submitted by way of claims for those bills, make a determination of what should be paid, issue a certificate, and that certificate then is handed to LSA on behalf of the department, and LSA must pay. We have, as Mr. Dixon has set out, in terms of normal public accounting, the guidance in terms of looking at public funds, we have no skin in the game apart from paying the bill. So the PAC recommendation was essentially to say it needs to come under the purview of the department. We need to consider it coming under the purview of the department and moving the assessment process into the Department of Justice so we can set fee frameworks and an associated assessment process. As I say, we did some work in early days in 2017. I think we were overly ambitious, to be quite candid, in terms of the scope of that project, the availability of data, the actually evidence any change. We've got caught up obviously with pandemic and other things, so it's been, quite candidly, fits and starts. Where we got to, when I came into rule, reviewed where we were. Last year we set up a dedicated branch for taxation reform, and that's made significant progress. So, Mr. Dixon, just to answer your question directly in terms of what steps we've taken, there's the branch has been established. We've made, for the first time, we've had access to the taxing master's office and the taxing master's files. I'd like to place on record my gratitude to the taxing master and her office for facilitating that. That's the first time we're actually able to see what was being submitted, what was actually coming through rather than the end result. So very grateful to that. Grateful to the profession, particularly the Law Society, who have engaged this year in terms of helping us understand how their time and line bills are put together and their views on where we move from that. We've also decided and made decisions in terms of the programme board that the first area that we are moving to bring onto the purview of the department, because it is a very complex area and we've taken a phased approach, is High Court bail applications. Now, High Court bail applications only make up about 2.5% of the, about 2.5% of the spend that is in the public, in the legal aid, in the taxation space, but it's almost 17% of the volume of cases. So we think if we can capture a significant volume of low-level figures, that'll help us understand and develop our thinking around the assessment process and actually stress test that in a fairly safe environment. At the moment, we're planning to present proposals to stakeholders by March 2025 on High Court bail, fee structure, and how we can actually bring that in then on the assessment process. We've separately looked at two other areas that we're currently exploring in terms of the research stage, and that's Criminal Court of Appeal and judicial reviews and associated costs. I think it'd be fair to say our assessment in terms of across the taxation process and the taxation fee structure at the moment, there is a wide variance in terms of the bills that are submitted. Sometimes difficult to understand the basis, quite candidly, of what they are. We're still trying to understand what brief fees are.
Yes, we've asked that too, how are they calculated? We're still waiting for that answer, but I'm sure we'll get it.
Right. Well, we're still in the process of engaging with the bar on that, and we haven't got to that. So that's one area that we just are completely unsighted on. So it'd be difficult to come up with a fee structure that accommodates brief fees or addresses the principles of a brief fee if we don't know the building blocks. So we'll keep engagement with the bar on that. So a number of steps, Mr. Dixon, in terms of moving forward to actually go from landscaping, the fits and starts that we've had. We've now got a dedicated team. We've got access to the tax and master's office. So grateful for that because it has given us the insight that we need, and good progress with the Law Society, less so at the moment with the bar, but that's work in progress, and I know there is a real commitment from the bar to engage with us on it. It's just we haven't got to that point in terms of understanding the fee structure. Some examples in terms of fees and the variances, Chair, Mr. Dixon. And if it's helpful, Chair, I'm more than happy to provide a more detailed written briefing on this, because it covers a lot of ground, but it can illustrate the actual high costs that are associated with some of these areas. Criminal Court of Appeal, I've been approached by a number of people, both within the Bar, the Law Society, a couple of members of the Judiciary, saying if you want to sort something out to reduce costs in the legal aid space, look at Criminal Court of Appeal because of the high cost items. And again, I'll just make sure I'm quoting my own proper figures here that I have. Criminal Court of Appeal in 23-24 financial year represented 2.8% of the volume of cases that the taxing master assessed. But it accounted for just under 10% of the cost out of the legal aid fund. And just by way of update, Mr. Dixon, in the 23-24 year, £26 million was expended out of the legal aid budget on order of the taxing master, which is almost 25% of the spend in that year. And what we're seeing is fees that are paid by the prosecution service to their counsel. I can give a couple of examples. And I'm not saying that these are typical, they're just a couple of examples in the sample that we have. Junior counsel paid by PPS for appearing in Criminal Court of Appeal, just under £700. The junior barrister equivalent on behalf of the defence received £15,000 after taxation. You can see the difference of other examples in that space. I don't want to be alarmist, and I don't want to say that those are the but there's clearly room for reductions in that space. There's a little bit of alignment, but I'd have to be sure there's certain areas as well in the taxation space. I think we need to look at upping the figures as well to rebalance. I think there's certain areas that are going to cost us more money and should cost us more money to be fair in remuneration. So potentially look at redistribution in that space. But there are some stark figures that are coming out of our analysis. I hope I've covered, apparently just going on there quite a bit, so apologies, but hopefully I've covered most of what you've asked for, Mr. Dixon. I'm happy to, as I say, provide a more detailed briefing on the analysis and the detailed plans moving forward.
Thank you, Stephen. Stuart?
Yes, thank you, Chair. And I think that's been very useful by way of background. These are essentially bills that legal professionals put in against the court cases which they have participated in and are entitled to receive legal aid. But the taxing master is not within the purview of public sector finances, and I think that was the key or the heart of what the Public Accounts Committee and the Auditor General was saying in the report which they wrote. And I think the change in legislation I think is important because it brings public money under public control in terms of it has the potential to bring public money under public control. I think you're right. There will be swings and roundabouts in terms of all of that, but there are very large sums of money at play here, and this is public money, which is not. And as I say, you've even surprised us by saying that. And it's welcome that the taxing master, she has given the opportunity for you to look at this. Have you been able to analyse just exactly the pattern of work that's undertaken, the how, where, what, and why bills have either been reduced or I don't know? Does the taxing master have the power to increase a bill? Because you have said that some areas might be underfunded. So I think it would be very helpful to the committee if you were to be able to share both recent data analysis, which demonstrates progress in reducing such claims, and just exactly what the level of collaboration is between the department and the taxing master, and what transparency there is between both of you in terms of this. But I think ultimately, Chair, it would be very difficult to escape the requirements of the Auditor General and the Public Accounts Committee when it says that this function should effectively be transferred to the department or to an independent assessor appointed by the department to carry this out with public scrutiny and public accountability.
I'll take a couple of points there just in terms of the taxing master, because clearly I respect the independence of the taxing master. They have afforded access, which has been the first we've managed to get there, so it's broken new ground for us. We are getting an insight in terms of the papers, in terms of the sort of areas that the tax master would typically reduce in some of the bills that are coming through, and sort of the level of percentage cuts in that. And I think it's important to highlight that the tax master and the PAC recommendation, I think, also was based on and recognising the tax master was reducing bills on average by 9 to 13%, I think, in 26. What we're seeing in some of the samples that are coming through and some of the information that LSA share with us, that there are bills being reduced by upwards of 50% and anything between 0 and 50% by the tax master in terms of what's being submitted and what she's actually then ordered to be paid. And it goes again back to that, how do we actually understand the building blocks of a brief fee if the tax master, with all of her experiences, is able to bring to bear a reduction of 45% on a bill that is submitted.
Yes.
So we're still working through the how, because we all have to understand the how to develop the assessment process and the policies for legal services agency staff to replicate the principles of that. And then we also have to understand the building blocks of the fee structures and the brief fees and so forth to be able to come up with a secondary legislation that introduces a set of fees for criminal court of appeal, divorce, whatever it may be.
Oh, Stephen, thank you. Deirdre?
Yeah, no, thanks very much. It'd be good to get the written update when you can provide it. That'd be useful, because this has come up. And I know for me, one of the things that throws me is the fact that solicitors have to itemise their costs where barristers don't. And do you see that changing then in terms of bringing greater accountability and oversight?
I think we have to be honest, look at that, because I've been very candid with the bar in my opening correspondences. I have next to no idea how a brief fee is made up. Yeah. That's genuinely the truth. And until I get that granularity and understanding, it'd be difficult to say, do we move from that? Because if I get an understanding that says, yeah, I get it, that makes sense, you don't need to do time in line, but it's such a difference between what solicitors submit and the time that they have to go 15-minute time in line, how much is spent on an email, this, that and the other, to a 4 or 5 page narrative or a 100-page narrative saying, this is my brief fee.
Have we any understanding currently, as it currently sits, around why solicitors have to itemise but barristers don't? Is there a rationale that's there for that?
I'll need to go back. It could be something to do with the Law Society's rules and regulations. It could be the bar's rules and regulations. It's certainly not ours.
Yes.
So I imagine it's in that space, but I'll come back and confirm.
Yeah, no, that would be good. Thank you.
Yeah.
Thanks, Deirdre. Anybody else have anything on this?
Section 4, clause 22, delegation of powers by the policing board to members of the board or board staff in relation to ill health, retirement, pensions, injury and duty and other miscellaneous benefits. I would welcome that clause, but just for clarification, will there still be a scrutiny, an oversight scrutiny within the board itself of any decisions taken by any delegated authority within the board?
I think that answer that's for me.
That's for you, sorry.
Yeah, no, that's grand. Yeah, I think obviously this provision will allow any board members or any of the committee members to delegate functions to officials should they wish to decide to do. I know the initial concerns about it, we had spoke to other departments and other departments have narrowed delegated powers, including on a schedule of delegations. Obviously we wrote to the board about that and asked could they provide a schedule, but the Chief Executive has informed us that obviously members would need time to consider that and still working out, but at the minute all board members would be making any decisions in relation to any of those.
Welcome clause.
Yeah.
Thank you. Thank you, Chair.
Thanks, Morris. Anybody else? I have a couple of bits. Shocker. If I could take you to the extending security of around tribunals, that whole issue. There's again, it's indicated there's no cost. Could I ask you what you intend to do? You know, what are the outworkings of this? And if it's at no additional cost, why is it not already being done?
Well, the official who was here to speak to those provisions, Chair, has had to leave because she had a legal consultation this afternoon. But I can speak to it at a very high level. Or you might want to spare my embarrassment and we could offer you a more detailed answer in writing. It's entirely up to yourself.
Well, I suppose if you could give us some indications to what you intend to do, like all we need, Andrew, is to make sure that we're going into second stage informed.
Yes.
So I'm not asking you for,
Okay, it's not that the courts are seeking to do a power grab. This is purely to allow for scenarios where perhaps there's water damage to a court building or a building or a premise which is used for tribunal purposes. And because those buildings are listed in legislation, security officers can only provide their services at the premises that are listed in the parent legislation.
Okay.
So this is an order taking power which would allow the courts to designate alternative buildings in the event that that's needed. And the reason why it's no cost is because the existing security personnel
moving from one place to
would
the next.
move from the premise which can no longer be used to the new premise.
Fine, thank
So
you.
that's the summary of my level of understanding of it. I hope
That's okay,
that's
because
sufficient.
that's what we need to understand at this stage for
Okay.
second stage on Tuesday.
Sure.
Could somebody please explain to me this no build thing? Because what I'm not clear about was, you're up, Em, are you? You're trying to get us. I suppose I'm not clear why lesser charges wouldn't apply. Could you just work us through
No
that, please?
problem, yeah. If you're content, Chair, I'll maybe explain the current offences that are in place, the gap that's been highlighted to us and why we consider it should be closed. Great. So Section 5 of the Domestic Violence Crime and Victims Act 2004 created an offence of causing or allowing a child or vulnerable adult to die. This Section 5 was then amended by the Justice Act Northern Ireland 2015 to extend the offence to cover causing or allowing a child or vulnerable adult to suffer serious physical harm. So this Section 5 offence, covering both death and the serious physical harm, was intended to address the problem where a child or vulnerable adult dies or suffers serious physical harm. There are two caregivers or potentially more within the household. There's no evidence they acted jointly, but it's very likely that one of the two caregivers caused the death or harm and that the other didn't take reasonable steps to prevent it. But there's no admissible evidence implicating one rather than the other, meaning there isn't a sufficient case for murder or manslaughter or grievous bodily harm, attempted murder. So under this offence, the prosecution doesn't have to prove which caused the death or harm and which allowed it. So Section 7 of that Domestic Violence Crime and Victims Act 2004, this applies where a defendant is charged in the same proceedings with an offence of murder and manslaughter and with an offence under Section 5 in respect of the same death. So this Section 7 amended the procedural and evidential rules, meaning that when a magistrate's court is considering whether to commit a defendant for trial for the offence of murder or manslaughter, if there's sufficient evidence to put them on trial for the Section 5 offence, so causing or allowing the death, there is deemed to be sufficient evidence to put them on trial for offence of murder or manslaughter. At the defendant's trial, the question on whether there's a case to answer on the charge of murder or manslaughter is not to be considered before the close of all evidence. So then in 2015, at the point where Section 5 was then extended to cover causing or allowing serious physical harm, a new Section 7A covering evidential and procedural rules was added. This very much mirrored Section 7 for causing or allowing death, but applies when a magistrate's court is considering whether to commit a defendant for trial for attempted murder, grievous bodily harm or non-fatal strangulation. Again, this means that if there's sufficient evidence to put the defendant on trial for the offence of causing or allowing serious harm of a child or vulnerable adult, it's automatically deemed there's sufficient evidence to put them on trial for the offence of attempted murder, grievous bodily harm or non-fatal strangulation. Again, mirroring the arrangements in relation to manslaughter at the defendant's trial, the question on whether there's a case to answer on the charge of attempted murder or grievous bodily harm, non-fatal strangulation, isn't to be considered until the close of all the evidence. So Section 7A made provision in the relation to the entry of a no bill for cases of causing or allowing serious physical harm, and this is where the gap arises. So it might be helpful if I just explain the procedure in relation to the entry of the no bill, if that's okay. So Section 2.3 of the Grand Jury Abolition Act, Northern Ireland 1969, makes provision so that a judge in the Crown Court has the power to enter a no bill in the Crown Book in respect of any indictment presented to it if he is satisfied that there isn't a sufficient case to justify putting a person on trial for the indictable offence. So if the judge enters the no bill, the charge would then drop. So in the context of these provisions, this means that a judge in a Crown Court can only enter a no bill in relation to attempted murder, grievous bodily harm or non-fatal strangulation if they also do so in relation to the Section 5 offence of causing or allowing serious physical harm.
Emma, hang on.
Sorry, going too much.
No, it's not your. Let's take a step. What is no bill?
The no bill is the judge can enter that in the Crown Book if they don't think there is enough evidence to proceed, and then that would then drop off. So an application can be made to the Crown Court for a no bill, and then the judge, it's judicial discretion, consider whether there's enough evidence to put the person on trial or not. Is that?
Yes,
yeah.
Carry on.
No problem.
Not sure I'm there yet. But
Okay,
I'll get there eventually. All right.
Yeah, no problem. So really the restrictions on the entry of a no bill are needed due to the evidential difficulties in such cases, and it's to ensure that the evidence is heard for all the charges before the judge considers whether any of the charges should be dismissed. So this removes the risk of the more serious charges of attempted murder, grievous bodily harm, etc. being dismissed prematurely, so before all the evidence for the whole case has been heard. And then the gap equivalent provision to restrict the entry of no bill hasn't been provided in relation to causing or allowing death in 2004. We believe this was an oversight. The proposed measure is intended to resolve this. So as it stands, it would be possible for a judge to dismiss the murder manslaughter charge whilst continuing with the causing or allowing the death of a child or vulnerable adult. This isn't the policy intention, and it's not in line with the equivalent arrangements in England and Wales. In that jurisdiction, a judge cannot enter a no bill on the charge of murder and manslaughter unless the charge of causing or allowing death is also dismissed. So this gap was raised with us as an urgent concern by Judge O'Hara in the ruling on an application for a no bill made by a defendant in a case involving the ill treatment and death of a 5-year-old child. Judge O'Hara commented that the legislation as it currently stands with the gap is illogical. In this particular case, though, he noted that he was satisfied that it would have been open to the court, open to the jury on the available evidence to convict the defendant of murder, though if required, he would have used his judicial discretion to refuse the no bill. However, Judge O'Hara referred the judgment to the Minister and the Department so that as urgently as possible the gap in the legislation could be filled. Do you want me to keep going, or I don't know if that's any clearer. We can provide our...
Do you know what would be helpful?
Yeah.
Is there any chance that you could send us this explanation through so that we would have it for Monday in order to prepare our remarks for Tuesday? I mean, that was something I was really struggling to get my head around.
Yeah.
I think it's one of those ones we may need to see
rather
than listen to.
I think so. You
Does
need
that
to
make
kind
sense?
of follow through
so that we can kind of work. Is everybody else in that boat? Thank you.
I've worked in the civil service for 39 years, and I've been working with policy and legislation for the last 19, and I don't understand this. So you're not alone, and this is one of the reasons why you have my sympathies in terms of the complexity of the provisions of the bill that you have to scrutinise.
Well, yes, thank you.
Repeat those words to you as we move through this.
I'm an open book, so...
I think that would be helpful. Emma, thank you. I think it has helped to elucidate it a bit, but I think probably we all need a wee bit more percolation of that one, if that's all right.
Of course, okay.
You've done that one for me. Yes, there's a couple of things I suppose we'll pursue. The Law Society had flagged up some concerns around the unintended consequences of the contingency practice, on conveyancing practice, and this is the business about clawing back legal aid under property, you know, where that's awarded. They'd flagged up, but I think we can pursue that at further stages as we move through. The one thing I do want to check with you is, yes, the provision in the bill around legal aid where it's essentially it's a future proof, where you're saying, you know, it's not going to be implemented. It's about alternative methods of determining remuneration. It'll not be commenced, but it'll take effect project by project. Okay, that worries me, because it seems to me we're being asked to legislate in a vacuum, you know, on stuff that's not going to be commenced. Project by project concerns me about what it means in practice, how we'll establish consistency, you know, across the piece. Stuff like that, I think we will need clarification on going forward. I'm flagging it up to you at this point. You may not, I mean, I'm conscious of time, and you've been more than generous with yours, but those are areas where I still want to understand what that looks like, because, you know, it's not clear.
I can touch on it briefly, Chair, conscious, as you say, if you're time. And I'll include this in the written briefing that I've committed to earlier. This amendment in the bill is really a precursor to the taxation reform that we discussed earlier. It simply removes any sense of taxation being available if the department introduces legislation, supporting legislation, setting out a fee framework for whatever area. And all this, at this point in doing it by way of reassurance, is really simply clearing the ground for us to take forward the reform to remove taxation master's role and bringing that into the department. In terms of the sequencing, I mentioned earlier about High Court bail. High Court bail fee structure at the moment, when we move to proposals on that, we'll have to introduce that after consultation through the Assembly, properly scrutinised by yourselves. And at that point, that's when this amendment bites, but it only bites on that particular provision. So it doesn't bite on any other fee structure. So every time we bring a separate instrument, and there will be a range of separate instruments coming forward on High Court bail, Criminal Court of Appeal, divorce.
You can hardly wait, Steve.
I know. You can see the enthusiasm I have as well on this. They are complex, but if it's any way of reassurance, Chair, I can set out sort of the high-level plan in the paper to you in terms of what you can anticipate over the next 12 months, 18 months. I haven't got as far with my team in the very complex area of family and civil, because it involves children, and it's just complex.
No, that will be helpful, just so that we've got a context for this. Does anybody have anything else, finally? No? I suppose on that basis, can I thank you? You've all been really generous with your time. We greatly appreciate it, because, you know, there's a raft of things in here. It's not straightforward for us. So you've been great. Thank you. I suppose just a couple of things to finish with, if I could ask you. With regard to the Delegated Powers Memorandum.
Yes.
Obviously there's a considerable number in this bill. And
there's about 8 in total.
Which is a fair whack. So an executive guidance would be that would be with us.
Yes, I hold my hand up to this one, Chair, and apologise that it's not going to be with you as soon as I would have liked. It should have been with you before second stage, with the best will in the world, and with the rapid change in timetabling, with the Speaker given clearance late on the evening of Monday the 16th that we could actually introduce the bill on the 17th. I was working to a timetable which afforded me another week in order to prepare for second stage and subsequently to get the Delegated Powers Memorandum to you. I was working on it on Tuesday. It is now a priority for me to complete for you, and we will have that with you in the next 2 weeks.
That's great, because it also means then the examiner can start her work and inform us that way, so that's helpful. The other thing is, like, you'll also appreciate within this we're being asked to look at the Justice Act, we're being asked to look at pace. I mean, and to be honest, and it's omit this, and you know, we don't know the context in which that is coming. You know, you guys have had this, you know, we don't know. We don't know what the change actually looks like, what's there currently, and what it will move to. So, I mean, we've had a conversation around this, and we consider that a Keeling schedule would be incredibly helpful for us in this regard. If you could see your way to providing it, it would be very helpful for us.
We've had a conversation with OLC, and they actually considered this to be an unusual request. It's certainly not something that the department has provided. In fact, I wasn't even aware of a Keeling schedule as an item until it came to us in correspondence as part of this bill. Certainly not something that's ever been produced for any of the 10 to 12 bills that I've been involved with since devolution. As I said, our OLC drafters, and one is a very senior officer, said that he had never prepared or produced one. To try and produce one would require deflecting their attention from the drafting of amendments, which the department has or does consider to be the priority. Even if we were to make a request of them to produce, if something could be produced, they're under no obligation, because it's not something that's set out in standing orders or any kind of guidance that has to be produced or should be produced. So I've just give you a very short summary of my civil service career. I've never seen one. I've certainly never been responsible for producing one and chairing one for any piece of legislation that I've ever done. Although without knowing what it was, I've done something similar for legislation that I've been responsible for at secondary level. So I understand the thought process behind it. It is helpful to see the legislation in its future form, in its entirety. It does help with that understanding. But in terms of us commissioning a report for you on this bill, I wouldn't be optimistic that it's something that we could do at this stage.
Well, we're still asking for it, Andrew, on the basis that I think we're now, I mean, a number of us have not been through the bill process before. And our first bill then is, you have to look at the Justice Act for this, you have to look at the Pace Code over here, we're omitting this and amending that, and we have no idea of the setting or what it'll look like. So we consider it would be incredibly helpful for us. And to be honest, from our point of view, we also have things coming in ad hoc, when our view was just hold it and make it all ready. So what we're saying is we would like it, we think it would be helpful, and certainly following a real indictment of a judgment against the department, against a predecessor committee and against the Assembly. We want to make sure that we are taking forward our due diligence and doing as much as we can. We're not asking for it to make life awkward, we're actually asking for it so that we have a better understanding and that we're not legislating without understanding, because I think that responsibility is on us to scrutinise legislation and make sure we fully understand, and we would be remiss in our duties if we didn't understand the context in which we were being asked to consider policy proposals on very serious issues. So I'm going to ask you to take that away and give it consideration. It is something that the committee has been unanimous on, and certainly I have pressed the clerk to pursue that. So I'll ask you to take that away and give it consideration.
I'll escalate it within the department.
Thank you. We can ask no more than that. So let me see. And also, I'm familiar that it may well not have been done justice, but other committees have received it in the past. So on this one, I think, you know, this is where there were problems previously. So eyes are on this committee, eyes are on this bill, and I think it's in all of our interests to make sure we're doing it the right way and CYAing it. All right.
Take it away, Chair.
Folks, thank you so much. You've been more than good, and we're extremely grateful to you. It's been incredibly helpful. I think that will help us enormously for second stage on Tuesday. It's considerably overrun, but I think this will help. This conversation will help us in the long run as we move through. So thank you very much to all of you and your officials.
Thank you.
Thank you. Members, just on the back of this now, before we proceed, could I ask you, could I seek your agreement to commission the examiner's statutory rules to now scrutinise the bill's delegated powers? Members agreed? Agreed. Thank you. Could I also ask that we publish all bill-related documents on the committee's webpage?
Agreed.
Thank you. Agenda item 5 is the budget update and October monitoring round from the department, and there's oral evidence. I'd refer members to pages 319 to 539 of the meeting pack. Again, officials are going to be in attendance, if they're still out there, to provide a briefing on the department's budget and October monitoring round. Are they there?
I just want to check, Chair.
There should be. I'm going to swap books. Can I thank you all so much for your patience and apologise profusely, but you'll appreciate that the bill we have in front of us is enormous and really serious. So we wanted to make sure as we're heading into second stage on Tuesday that we fully understood. So sincere apologies. We'll not keep you any longer than is necessary, and thank you so much for bearing with us. So we have in the meeting Deborah Brown, who's the Director of Justice Delivery, Richard Logan, the Head of Financial Services Division, and Andrea Quayle, Head of Financial Planning, Strategy and Support. All, you're very welcome. I'm going to invite you to give your presentation, and then we'll have some questions. Thank you.
Thank you, Chair. So good afternoon, and thank you for the opportunity to update you this afternoon on the department's budget. So, as the Chair said, I'm joined this afternoon by Richard Logan, who is the department's Finance Director, and by Andrea Quayle, who is our Head of Financial Planning and Strategy. So this afternoon we want to provide the committee with an update on the department's 23-24 annual report accounts and final outturn, as well as the 24-25 urgent in-year exercise and the imminent October monitoring. We'll also provide you with an update on the 25-26 future years exercise and the current status of the department's transformation proposals. It's important to emphasise at the outset the ongoing budgetary challenges which are facing the justice organisations. The committee is very aware of the previous briefings that we have provided, which have outlined the very challenging budget to date for the department, and one that is going to require and has required very careful financial management and in the future some very difficult decisions in order to reduce the risk of an overspend in the current year. The issues and the concerns have been widely documented in the media and debated by the Assembly, particularly in respect of the financial pressure which is facing the police service. We very much value and appreciate the constructive engagement and support shown by members of the committee in continuing to highlight and discuss with the Assembly colleagues the issues facing justice and the critical need for additional funding. The committee will be very aware that the severity of the financial position facing justice is exacerbated by the combination of historic underfunding compared to need and the demand-led nature of the majority of the services that are delivered by the justice organisations. In addition, the department's business areas are having to manage inflationary costs, increased pension contributions, as well as the full year impact of the pay awards from 23-24 and the new pay awards for 24-25. Despite the erosion of the department's budget over the last number of years and the growing demand for services, the department has been proactive in taking difficult decisions to reduce and manage the pressures where possible. However, we are now at the point where all options have been exhausted in terms of the department's ability to absorb any future pressures and still keep within that budget. Richard will give us more information on the budget later. Just to give you the position on the 23-24 annual report and accounts, on a very positive note, pleased to confirm that the Department's annual report and accounts were successfully laid in the Assembly by the summer recess deadline of the 5th of July this year. The accounts received an unqualified audit opinion from the Comptroller and Auditor General. This was a significant achievement given the additional complexity and the volume of work that's involved in consolidating the accounts of 15 organisations within that departmental boundary in order to comply with the new requirements that are set out in the review of financial processes. And on another positive note, looking at our 23-24 financial outturn, that was submitted to the Department of Finance on the 19th of September. In terms of our main budget of £1.26 billion on Resource Del, the Department achieved an underspend of only £37,000, which is less than 0.003% of the budget. This is the Department's smallest underspend in both monetary and percentage terms since its formation in April 2010. This result reflects the strong and effective financial management which is exercised by the Department in terms of maximising the limited budget that it had available. However, it also clearly demonstrates how finely balanced the Department's financial position really is and supports our position on the Department's requirements to properly fund the justice system. The Department spent all of its budget and it has no scope to absorb any further costs in the absence of additional funding being provided. I'm now going to pass across to Richard, who's going to give you an overview of the budget.
Thank you. Thanks, Deborah, and thank you, Committee, for the opportunity to provide this briefing. Turning to the 24-25 financial year, the Department of Finance commissioned an urgent in-year information gathering exercise on the 5th of August. The information provided will be used to inform executive decisions on managing the overall level of forecast departmental overcommitments. The Department's return was submitted to DOF on the 30th of August, and a copy was shared with the Committee on the same day. The return showed that we are currently forecasting an overcommitment for stabilisation pressures of £47 million compared to the £86 million previously reported to the Committee on the 8th of July following the outcome of June monitoring. And stabilisation pressures, they relate to the day-to-day operational costs of all organisations, including their pay. The level of pressures remaining needs to be viewed in the context of prison numbers an all-time high, 27% higher than 2021, increasing legal aid demand, the recovery from COVID, clearing backlogs in courts, and the pressures facing PSNI. Whilst recent focus has been on the PSNI budget pressures of £37 million, significant pressures of £9 million still exist in legal aid costs, which are truly inescapable. Every effort has been made and continues to be made by the Department's business areas to reduce the level of pressures, but this has not been achieved without adversely impacting the justice system, particularly, but not solely, the police service. In addition, the Department has also reported exceptional pressures of £227 million in respect of legal claims for holiday pay, McLeod injury to feelings and the PSNI data breach. The costs of settling these claims are not affordable within the Department's existing budget under any circumstance. Therefore, in the absence of sufficient additional funding being provided to DOJ following the urgent in-year exercise, there is a real risk of an overspend by the Department in 24-25. The seriousness of the Department's financial position was again raised by the Justice Minister at a bilateral meeting with the Finance Minister on the 17th September. This was one of a series of bilaterals with all ministers to discuss the in-year financial position ahead of the Finance Minister bringing recommendations for allocations to the Executive. In terms of the October monitoring round, this has not yet been formally commissioned by DOF. The timing of the urgent in-year exercise in August preempted some of the normal aspects of the October monitoring round. As a result, the exercise will likely focus on technical items such as transfers between departments and between business areas within the department itself. And I will ensure that a copy of the department's return and the outcome of the October monitoring is provided to the committee as soon as possible. Turning now to the 25-26 future year exercise, DOF commissioned this exercise on the 22nd of August with a return date of 4th of October. And this exercise seeks to capture information for the next 3 years to assist the Executive in considering the longer-term implications of spending decisions. In terms of planning assumptions, DOF advised departments to use the Budget 24-25 position announced on the 29th of May as a starting point for all 3 years. So for DOJ purposes, our planning will be based on a budget of 1.218 billion for the next 3 years. And as advised by DOF, this excludes earmark items of £31 million for the additional security funding for PSNI and £13 million funding for the Tackling Paramilitarism programme. The funding for these areas will be confirmed in due course by DOF. Crucially, the planning budget also excludes the £35 million allocation the Department received in June monitoring and will exclude any subsequent monitoring round allocations. These are non-recurring allocations at this stage and they don't form part of our baseline. We are currently reviewing the returns received from business areas and drafting the Department's consolidated return. However, it will come as no surprise to the Committee that from our initial review, the future financial pressures show no sign of relenting for justice organisations. One of the key elements of the pressures relates to pay costs. It's currently estimated the Department's pay bill for 24-25 will be in excess of £900 million. This means that every 1% of a pay award will cost approximately £9 million. So, for example, a 3% pay award would cost in the region of £27 million each year. And we set this against a planning assumption of flat cash budgets for the next 3 years. This would result in an annual pay pressure of more than £81 million in 27-28 if pay awards were set at 3% each year. Of course, in addition to pay costs, significant pressures have also been reported across many business areas, including legal aid, prisons, courts, and of course the PSNI, in order to stabilise policing in the immediate term and increase police numbers over the course of the current mandate. However, the reality is that without additional funding, it will not be possible for these issues to be addressed from within our current budget. We have now reached the point where, in the absence of sufficient additional funding, the Department will no longer be able to absorb the additional costs that will inevitably come in future years. The level of future budget allocation will also have implications on our ability to deliver the Minister's priorities in the departmental business plan and the priorities of the Executive within the programme for government. We are still, however, going through the details of the returns from business areas before submitting the return to DOF. And as with the October monitoring round, I'll ensure that a copy is shared with the committee as soon as possible. On a more positive note, before I finish, we have received very encouraging news that 3 of the Department's transformation programmes were successful in moving forward to the next phase of assessment by the Interim Public Sector Transformation Board. So that was electronic monitoring, the prisons proposals and the speeding up justice proposals have been taken forward for further consideration. And again, we'll keep you updated as the process continues.
Can I check it? 3, not 4? Our paper said 4.
The 4 went to the next first step, and then on there was a series of presentations last Wednesday. So it's an up, yeah.
So the Tackling Paramilitarism one didn't make it through to the next stage, but we do understand that there's the opportunity to further develop it, and because it's over the 5 years, the Transformation Fund, we can resubmit something next year as well.
Okay, sorry.
That's okay. In conclusion, I trust we have provided a candid but helpful overview of where we are now in terms of the financial position. We continue to operate in a very uncertain financial environment, and the Department's position remains extremely challenging in terms of living within the budget made available to us. I'd like to thank you again for the opportunity to brief you today, and as Deborah mentioned earlier, we very much value your role and views, and we're happy to take any questions. Thank you.
Thank you very much indeed.
Justin?
Thank you, Chair. Thank you, folks. Who is the Chief Accounting Officer of the Department of Justice?
Chief Accounting Officer is Hugh Wittes.
Where's he?
Permanent Secretary.
Where is he?
Where is he?
He's in the office working.
Will he not be here to present the budget information from the Department on behalf of the Department?
Sorry, I couldn't make out what you said there.
Should he not be present in terms of presenting the budget picture on behalf of the Department?
No, usually it's the Finance Director that just would come along with colleagues in order to present the budget position.
Okay. In terms of your statements that the budget will impact the ability to deliver the Minister's priorities, is policing not one of the Minister's priorities?
Policing is absolutely one of the Minister's priorities, and she has said that on record.
And she has outlined, or you've outlined, the seriousness of the department's financial position has been set out by the Justice Minister in bilateral meetings with the Prime Minister. I don't quite understand how that juxtaposes with also the position that the Chief Financial Officer of the department has admonished the Chief Constable for seeking a better budget position from the Prime Minister. I don't quite understand that.
As an accounting officer, as per managing public money, accounting officers must live within their budgets and they are not allowed to overspend. And in that context, that is why our accounting officer wrote to a sub-accounting officer, the Chief Constable, to outline those responsibilities and also to highlight that the proper process is for us to engage with the committee and others to put forward our proposals, which then go to the Department of Finance, who in turn then engage with Treasury on these issues, and that is the proper process.
Is it the Chief Accounting Officer's position or role to admonish the Chief Constable with or without the support of the Minister?
I'm not sure the officials can answer that. That's, I mean, these officials sit below that person and you're asking them to make comment on their boss. And also some of those questions are maybe political in nature and need to be answered politically rather than at an official level.
Thank you, folks.
Is there anything else that you want to ask around? I mean, I don't want to shut you down on some of this stuff, and I honestly I think that the issues you've raised are really valid. I'm just not sure that the officials here are in a position to speak to those issues. Is there anything else you want to raise with regard to the budget?
I do think there's a bit of an element of backclapping in relation to the department's annual report being tabled in time whenever, and also with £37 within budget, or sorry, £37,000 within budget, and yet the state of the department's financial position is obviously not very stable or secure for the future in terms of policing, especially whereby the police constable is coming out and saying that he hasn't enough money to keep people safe. So I'm a bit worried about the two different positions being trying to be paved here, and that doesn't make sense to me. Really.
The two issues are completely separate. The issue is the 23-24 annual accounts were prepared across 15 different organisations, and we successfully met the deadline. That is a reporting mechanism that is different from the budget issue, and I absolutely agree with it. We have a very difficult and challenging budget issue in the current 24-25 year.
I think it just sort of highlights as well, there was no wasted money in 23-24. We maximised the budget we had last year. We were able to bring forward some spend and get bills paid within legal aid and compensation services into the last few weeks and up to the last day of the financial year, which took pressures out of this year. Otherwise, we would have had even bigger pressures this year. So it was trying to maximise what we had available, and we will do this year. We will have to live within budget. But if the budget isn't sufficient, then that's what's maybe creating what's creating the other issues.
Yeah, I suppose the issues to which Justin refers are difficult. We're all aware that the Chief Constable is in a position of having to balance two statutory obligations. One is to keep people safe, and the other is to balance his budget. And at present, it looks like neither of those they're not compatible just at the minute. So the issues that Justin raises are valid. And I don't want to shut him down on that. But you've also outlined, look, they're just separate and distinct processes. So that's fair enough. Justin, do you have anything else?
That's great. Thanks, Chair. Thanks.
Thank you very much, Ciara, and then Stuart.
Hi. Just in relation to the transformation proposals, obviously we had a value of the 91.6 million that's in our papers for, and that was, I'm assuming, was for all the proposals that were submitted. We then, within our papers, 4 were successful for the second stage, and we have 3 now that are moving to the final stage. Could you give some clarity on just some insight into those projects and to the value, the financial value of them?
So the Speeding Up Justice and Transforming the Criminal Justice System, that is a bid which is for 40 million. So we provided presentations to the Interim Transformation Board last week and got back some feedback on each of them. I think that the challenge is that there were 11 proposals got through to that stage, and of course there's only a limited pot of funding. So they've asked us to go away and look at whether that particular bid could be scaled in any way. That bid has got a number of different elements to it, but some of the first stages of it are around work on early engagement and also out-of-court disposals. So the department is going to go away and look at its overall bid and see if it could break it down into certain different elements to see then if that would be successful. The Ending Violence Harm Hub was around about £16 million. That one has not got through to the next stage. It just needs to be further developed, but that was really just about looking at all the initiatives that there are across the board and actually addressing the issues at source. There is obviously still work ongoing on the Tackling Paramilitarism programme. That Tackling Paramilitarism programme continues to March 27, and there's currently engagement going on with the UK government to see if they will continue the match funding for the further 2 years beyond March 25, where they have committed to it. So there's still opportunity for us to further develop that bid and strengthen it and refine it. And whenever the bid's open next year, that's one that we potentially would put forward again. The Reducing Reoffending, the Prison Population Transformation Initiative, that's around about £9 million. And so that is looking at bail support, which would help to keep people out of the prison, and some other elements around ecos, etc. So again, feedback on that was just to strengthen the bid in some way. I don't have any more detail on what the feedback on that particular one was. And then the third one that has got through to the next stage is the electronic monitoring. So at the moment we have one in place, but it's just for the 12 hours when someone was in their own home. This one would have GPS and would allow to have a more sophisticated system, and it would take the pressure off the police and other areas. I say that's about £2 million, and again that has got through to the next stage. So the next stage is to refine the bids that were originally put forward within a 3-week period, and then they'll be reconsidered at that point.
Thank you. It'd be useful just to get an update as and once they are refined and how they go forward. But I suppose it's great to see additional investment through the and I suppose transformation is very important. Just one other one in relation to the digital landscape element. There was no bids submitted from the department.
There are digital elements within the Speeding Up Justice. So within that there's the Causeway. So at the moment we're upgrading Causeway. And so there are opportunities within that Speeding Up Justice that would then allow us to take that forward. Within the transformation bids, there were a number of specific digital bids, and they're looking at pulling them all together. So we have made representations to say that there are elements within our bids that have digital aspects to it, and how could they be incorporated. So we haven't got any feedback on how that might work moving forward.
Thank you, Deborah.
Stuart?
Thank you, Chair. A number of things just around the budget pressures, and of course the element in the elephant in the room, if you like, is the big issue around just the massive underfunding of the Justice Department. Basically, that the way it has been underfunded over a number of years, and even if money were to come in tomorrow, I suppose one of the questions would be how would the department actually manage an increase in funds, bearing in mind all the potential procurement and other issues which you will have to deal with. Just two aspects of the programme which you're undertaking to improve areas. One, in relation to electronic monitoring, that's an issue which the committee has addressed in the past, and one which the committee has strong support for, because we can see the value not only to the police in terms of reduced requirements for their attendances, but for much more sophisticated ways of monitoring those people who are tagged. I do have a concern around the priority with regards to ending violence against women and girls, given the high rate of violence and sadly murders that occur. and the fact that we have a strategy in place to deal with this, but it appears to me that we have a strategy but no funding or minimal funding to deliver on this. And so it's an area of extreme concern that any projects to deliver this do need to get through these processes. I think finally, Chair, just want to say in relation to the way in which the professional staff of the department have delivered the accounts. All too often, unfortunately, we do in the public sector and across government see areas of finance where reports come in late, accounts are completed late, or they're inaccurate, or they are sent back. So I think it is important that we place on record our thanks and congratulations to the professional staff in terms of the delivery of the accounting processes, right down virtually, as you say, to the last penny of this department, and the effective and efficient way in which, for example, those bills were paid within the last few weeks and days of the financial year in order to relieve a burden in the next year. And while that's a good and right and proper place to be, it's a place which in truth highlights yet again the extreme difficulty of the unbelievably tight budget, the impossible budget which the DOJ actually has to operate under. Thank you.
Well, thank you for those last comments, and I pay tribute to Richard and his team, who've done a sterling job in getting those all in time and to the quality and standard that they met. Just working backwards then, on the ending violence against women and girls, yes, absolutely agree with the points made. That's a TEO-led initiative, and whilst we did have a transformation bid around domestic abuse, that didn't get through to the stage that the other four did. We take some comfort that in the draft programme for government, you will see that under ending violence against women and girls, there is a paragraph at the end which does reference domestic abuse. So in anticipation that budgets will be aligned with programme for government, perhaps some funding may come our way in that regard. So I'll just put that out there. And then back to...
Wishing made it so.
And then at the issue about dealing with more money. So at the moment, our pressures are the £48 million. The majority of that, 36.7 million, sits with the police. That's all money that relates to pay and other inescapable costs that they have outlined. So we know that that can be spent, potentially will be spent, and could result in potential overspend, so that's a concern. 6 million of that is in relation to legal aid, which you absolutely can get out the door before the end of the financial year. Indeed, that would only mean that the legal aid delays in payments would be similar to where we ended March 24. So that would make sure we were no worse than March 24, so that would be a 12-week delay. We have pressures which are greater than that, of course, because there is that 12-week delay, and based on our demand, and if we'd wanted to get down to 4 weeks, we should have been bidding for 15 million, but now that we're 6 months into the financial year, we couldn't get that money out the door, so we only bid for what we could legitimately put out the door. So I can guarantee that that money will be spent. The remainder is around legacy, of which approximately 3.5 million is actually legal aid associated legacy. So again, absolutely that will go out the door. At the moment, 1.5 million of that is certain, and we anticipate another 2 million. Of course, it is demand led, but that's our projections at this point. And the remainder is also associated with the legacy. So there is a little bit of uncertainty around that, but I think you can see that full 48 million is absolutely needed and will be spent if it is provided. And if it is not provided in full, the risk of an overspend is quite significant. I think those were all your points that you needed covered, Stuart, was it?
Yeah.
Yeah, thank you. Deirdre?
Yeah, no, thanks very much. And I suppose just to reiterate what Stuart said in terms of the accounts, but it does show how to the bone you are in terms of managing the money and the likelihood then of an overspend in the department. So that is something that we'll want to keep up to date with in terms of how that's going and how it's being managed. And I suppose it is getting the sense of, if we do get the multi-annual funding, it's not going to be the panacea, but will that help in some regards, and if so, how? The other bit then is around the transformation bids, and I would be keen, even outside of a financial point of view, to get more information on the electronic monitoring element, is that just for capital costs in terms of that GPS system, or is it for other things? But also in terms of these bids is about transforming the department, being more streamlined, looking at obviously the budgetary pressures or the pressures in the system in terms of numbers. So how, if you are successful, how is that going to be measured in terms of the effectiveness, either in a monetary term or on an outcomes-based term? So just if we could get some follow-up information on that, in terms of what framework is in place then for monitoring the effectiveness once these go through. And on any of the bids, are they one-off, or do you see the requirement to go back next year, you know, that they are being phased in any of the three that have got through to the next stage? And I'm assuming the one, I mean, I was concerned, like Stuart, on the end valence against, or sorry, the hub, but you said more work was needed on this, so are you looking to put that in next year again? So just to get a wee sense of that.
Yeah, so I mean, Adele Brown is a way to look at the harm hub and to further develop that, so work is definitely continuing to proceed with that one. With regard to, you know, the plans moving forward, obviously we're going on to the 25-26 exercise in the future years. Yeah. We're a demand-led organisation, so of course that's quite difficult to predict, but we're underfunded in so many areas. For example, in legal aid, the 94 million baseline is nowhere near meeting the annual demand of 115 million. So absolutely, the money that we get, we will absolutely be able to spend on measuring and monitoring. We have our business cases, which clearly outline what's going to be achieved and what the outcomes are supposed to be. There are mechanisms in place how that is measured. We have programme boards and oversight and to ensure that those things are being delivered, and we will have milestones within that to measure to make sure that we are delivering the savings. And all of those transformation bids are absolutely invest to save proposals. The challenge will be that they will not just save money within the DOJ, they will save money to the justice system and wider to health and other areas. So our challenge will be about how do you get that data and those metrics. So we're working with our economists and our statisticians to see what evidence base do we have. And again, in a climate where we are projecting an overspend, we're having to stop all discretionary spend. That means those sorts of evidence-based research that you want to do, you can't always do. First. Okay. So those are unfortunate positions. We have so many opportunities within this organisation to make massive change, make real difference to citizens on the ground, and to streamline and to make the system more effective. But there needs to be upfront investment before we're able to achieve that, because at the moment, unfortunately, we're just keeping the show on the road. Just about.
On that point then, are there other areas like that where you may be managing the money well, but it's still a lot of money that it doesn't need to be that much? So there was the example earlier through the legislation that's gone through in terms of the taxation master and legal aid that way, where there may be inflated costs within budgets, even though they're being managed, or they could be spent out before year end to justify getting the same money next year. So are you doing an exercise to identify that across the department?
Yeah, there are lots of initiatives across the department where we've identified this. So Stephen, Alison, we have a 5-pillar programme around legal aid. Taxation is just one strand. Yes. We've got civil that we're looking at. We've just finished our call for evidence on that. Lots of opportunities in that, and engagement with groups on the ground and understanding individuals' experiences and understanding how can you keep people out of a court system and get a better outcome for them and their families. Lots of opportunities within that. We've just got the Judge Burgess report on criminal legal aid. There's a lot in that, and we're only just working our way through those recommendations. So there are a number of strands in a number of areas across the board. Absolutely, I can give you some more information on what we are doing as a collective in the DOJ.
Aye, so across the whole family, including the judiciary and other angles. Okay.
That would be really,
that
really
would be
useful.
good. Thank you.
The transformation proposal funding is all resource. So because of our tight budget, all those programmes and initiatives we would want to do anyway, but we don't have the spare money now to invest in. So if we can get extra investment coming from transformation, that will open up the doors and let us make future savings and cost reductions in future.
Yeah, okay. Thank you. I'll be keen to come back once we know which programmes are going forward then, just to kind of look at
we
the
haven't got yet a definitive timeline from DOF as to when we're going to know the result, or when the money will flow through as well, because that's sort of saying, because we're now six months into this financial year already. The funding was to start this year for 5 years, so it's saying, will any of that be reprofiled in future years, maybe so that all the departments can get the full benefit of that funding?
Yeah. Thank you.
Understood. Thank you, Richard. Morris?
Thank you very much, Chair. Thank you very much for your presentation, folks. Doesn't make good reading in places, but anyway. Look, the projected overspend concerns me, especially when there's been an historical underfunding of policing and justice for quite some time now. We've inadequate numbers of serving and recruits, and you have this philosophy of you can do more with less, which adds a burden of stress on serving officers, and something somewhere along the line is going to break. My concern is, what services is the Chief Constable going to cut to stay within budget? I mean, we've heard there that as the Chief Accounting Officer, he has a budget, he must stay within it. He has quite publicly come out and says he can't stay within it, so something has to give. What is it?
Might be an issue for him.
Maybe it is.
Yeah, those are issues for the Chief Constable.
Operational issue. Yeah. I knew you were going to say that.
I think there were some ones in terms of what he's done so far, is closing some of the local offices and things like that, and pausing recruitment or not increasing numbers. So those sorts of decisions on pure numbers are happening, which will have an impact on certain services that the police are providing. But I think,
I know it's an operational matter, but maybe you could bring it up to the Minister. Leave it at that.
Thank you. I suppose just a couple of things. I'd want to reiterate, I suppose we have some concerns that what's become the priority in the PFG isn't necessarily reflected in bids that the department has made. We're disappointed about the bid on the abuse and so on. We share that disappointment with you. I suppose I also want to flag up to you, because you weren't in the room at the time, that we note in your memo that essentially you're having to look at cutting services and provision, and that's the position that you're facing, and I trust you know that we have advocated for you thus far. However, we do then kind of wonder, there's a raft of new proposals coming through, and we're being told that's going to be paid for through existing resources, so we're struggling to square that circle whenever you're saying you're going to have to, you don't have the money to do what you're already charged with doing. So they've given us some explanations, but I think we're going to withhold our position on that because none of us are convinced. The other thing that I want to flag up is just around the kitchen at McGilligan, which is not a small amount of money. My concern around this is £13.3 million for a kitchen when the department can't give me a breakdown of costs, can't give me whether or not there's been any change in spec, hasn't outlined what the change in scope has been to reduce it from, I think, 16 down to 13.3 million. Now, the reason that I'm putting this to you is in the context of social housing in my own constituency. There's one particular project where a considerable number of people were to be housed, and the spec on that has changed three times, and they still can't get a contractor to do the work. So, costs have increased, but the spec is reduced, and I'm not seeing that here. Also, add a few million more pounds onto that. 5 or 6 more million is going to get you an entire school. So I think that there needs to be a justification for a spend of 13.3 million on a kitchen and a cafe. Now, I want to clarify this. I've been to McGilligan and I've seen the need. I know what needs to be done there. So I do not dispute that there is a need at McGilligan. What I think some of the rest of us want clarification on is, how do we get to 13.3 million for a kitchen and a cafe? And to be honest, I don't believe that that's an unreasonable question from this committee, from me as chair of it, from me as an individual MLA, nor indeed for the general public to want to know. So I'd be grateful if you would come back to me on that, because it seems to me astonishing. I note that business cases haven't been considered by the department or the Department of Finance, but then how have you reached a figure of 13.3 million when you're not able to give us any detail on it? You can understand where we're coming from there. Is that all right?
Yes, certainly. I mean, at the moment it's a high level estimate, probably based on sort of square footage. So that's the sort of basis at the moment. So it hasn't gone out to tender. It's not even at that stage for procurement or anything like that. So we're not sitting with quotes coming in for that. This is preparation work on the business case to see what the range of costs would actually be. And I think, as you said, the need certainly, and that's where we're competing as a department against schools and hospitals, and there's need and people want to see that justified.
There is, and you can understand 13.3 million for what appears to be a kitchen and a cafe. You know, these people thinking, is this kitchen for Gordon Ramsay? You know, look.
The kitchen is supposed to be to the same standards that are in Magabry and Hydebank.
Yes.
And as you've noted, I mean, I'm not quite sure how the 13 million has appeared because they're still working their way through the business case, and the business case will have a range of options. I think it's also important to note that in McGilligan, the facility was not fit for purpose, and they had to bring in alternative arrangements at one point, if you'll recall. Mm-hmm. But they now have 500 prisoners in there, where they usually only had about 300. So the capacity is clearly not there for what they currently have. And the age of it and the health and safety issues that there would be around that. So again, absolutely, we will try and get you some more information, but as I say, the business case is not developed fully yet and the options are not there. So I think the 13 million is, as Richard has said, is an estimate of some description, but it will be subject to proper business case, proper options, proper challenge by us, and proper challenge by our economists before anything.
No, I understand that. And in my question to the Minister at the time, I understood, you know, I specifically asked then, okay, is there an intention then to even increase the number of prisoners at McGilligan? So you've got to be ready for that. But no matter what way you cut this cake, 13.3 million for a cafe and a kitchen, I think needs to be justified. So, you know, that's all we're asking for there. There's the dispute in McGilligan and the conditions in McGilligan are not in question here. All right. Thank you.
As well, the cafe element, it seems it's an element for the training for people, the students and everything to do that. So it's that sort of training the same way as maybe up in Hydebank. So it's that type of facility, the training and services can be provided there as well. So but we'll come back. Yep.
Richard, none of that under dispute. What we want to drill down into is how that's going to cost 13.3 million, you know, potentially. So that's fine. Does anybody have anything else? No. Could I thank you all once again? You've been inordinately patient and we're very grateful to you. Thank you very much. Thank you. Members, are you content that we share the October monitoring documents with the Committee for Finance?
Great.
Yeah.
Thank you. The next agenda item is an SL1, the Payment and Electronic Money Institution Insolvency Rules Northern Ireland 2024, and that's at pages 541 to 548 of your pack. The Department proposes to bring forward a statutory rule under Article 3591C of the Insolvency Northern Ireland Order 1989. The purpose of the rule is to set out the procedural rules for a special administration procedure for payment and electronic money institutions. The proposed Northern Ireland rules are similar in most respects to insolvency rules in England and Wales, but take account of differences in insolvency law here. Are members content with the proposed rule, or do you require any further information or clarification?
No, content.
Content. It seems to me this is a protection for consumers, investors, that kind of thing. Can I seek your agreement to forward the paper to the Committee for the Economy and the Committee for Finance for their information and perusal?
Great.
Thank you. Agenda item 7 is more police pensions. Police pensions amendment number 2, regulations 2024 consultation, and it's a written paper from the department at pages 549 to 555 of your pack. The department's proposing to consult on a proposal to amend the Northern Ireland 2015. How this relates to all the other police pension stuff that has come through, I'm not yet clear. Are members content to note the paper? Do you have anything you want to? Did you want to raise anything?
No, content.
Content to note?
Yeah.
For now, thank you. Agenda item 8 is Charlotte's Law, which is a report on the consultation responses and the way forward, and it's a written paper again from the department at pages 556 to 582 of your pack. So within that, the department has provided an overview of the responses to and proposed way forward on its consultation on Charlotte's Law. I think we all kind of welcome this very much. The public consultation ran from the 30th of November 2021 to the 14th of February 2022. Are you content to note this paper, or do you have anything you wish to pursue out of it, Deirdre?
Yeah, no, I would agree with the thrust of it and looking at the aggravating factors, but I would like to know in terms of how you would implement this in terms of options. So the department's thinking and what that would look like in terms of the aggravating factors. Also to look at the human rights implications. I know they refer to it in terms of the convention, but are there legal opinions, or did the department seek legal opinions? And if so, can we have a bit more detail on that? And the other bit was to look, obviously this followed on from Helen's law, as it said in the paper. So just really, has there been an assessment of how effective that was, or are there even gaps or deficiencies in that we can be in mind of here, you know, when we're looking to legislate around this? So I just think it would be useful to kind of get some of that information as we're moving through, but happy to note the rest of the paper.
I think that's fair. Members agreed then that we seek information around that. I suppose all of this will be developed as we move into the sentencing bill, and so we've got plenty of time, but it's useful to have that kind of ongoing in the background and have that information. Thank you. Correspondence. There's a correspondence memo and 5 items of correspondence at pages 594 to 617 of your pack. Sorry,
just to note the board work program.
Did I miss the board work programme? I did, apologies. Are members content to note the forward work programme? Anybody anything to raise on that?
The McGabbery, but is there a time for that yet? The visit that we got?
It'll be half 1 or 2, it'll get clarification.
Okay,
yeah.
Thank you.
Apologies for that, members. So we're back to the correspondence memo at pages 594 to 615. Are members content to note the items of correspondence as set out in the memo, or do you have any comments to make on them?
The only was, sorry, on the child exploitation one, could agree in terms of the definition and stuff, albeit I know for children and young people, I suppose they're looking in terms of their involvement as they're moving through this process going forward. I'd be keen just to see what TEOs tie in terms of tackling paramilitarism and the kind of policy responsibility there, because I know this is between obviously justice and education and stuff, but just what the TEO link is into this work.
Thank you. The other thing I would ask is, obviously we were asked to ask the department from Sammy Wilson about the airsoft, and we got a response on that. Now there's another response to come, but can I seek your agreement that whatever responses we get are sent to Sammy Wilson MP for his information? Yep. Thank you, that's great. Chairperson's business. The Deputy Chairperson and I held an informal meeting with the Independent Reporting Commission on Monday. Deirdre, do you want to give an update on that? How that went?
I suppose it was we met the whole panel. So obviously the 2 representatives, John and Monica, that are obviously selected by TEO, and then the Irish government rep and the British government representative that sit on that. So obviously they're in the middle of preparing the report for this autumn, and they were looking to have a discussion. There is some discussion around the potential to look at a scoping exercise to be done in terms of those prescribed organisations, and trying to identify if there is a willingness to transition and what that would potentially look like. And again, trying to create the legal framework and context then for things to be done, depending on the organisation and depending on the transition that would need to be done in that. I suppose one of the concerns for me highlighted is, I suppose they were trying to get a sense of the committee. We have said up until now we've tried to find consensus where we can, and there may be differences of opinion in terms of some elements of this work. But one of the concerns obviously is the panel themselves come to an end, their tenure next year. And so when you're looking at the Justice Bill, particularly this one, which will come as a late addendum, which is the Organised Crime Bill, which is some of the work that the panel have been trying to push, isn't going to come until potentially, did they say today, Christmas, was it for that one, or November? And the panel will already have their report out and will nearly be writing up its work. So I suppose they were just coming along to engage in the conversations, particularly around the British and Irish governments looking at this next phase of a process or a scoping in terms of trying to get an independent person to do a scoping. And I think we'll be waiting on a decision probably coming in the autumn or the winter, I thought. But the other elements is just around their next report and the implications that has, and particularly with the organised crime bill. I mean, that's, and then I had to leave, sorry, for question time. So
we're a bit kind of taken aback that we haven't received that information yet. Look, we also made the point that a number of the issues they wanted to talk to us about the committee hadn't discussed, so we weren't necessarily in a position to give a committee view on that. So we made that clear. Is that okay? You're content with that? We also, sorry, Morris. We also have received an invitation to hold an informal meeting with the Northern Ireland Commissioner for Children and Young People. Again, that's the Deputy Chair and I. Are you content that we would go and meet with the Commissioner? Thank you. Any other business? No, we've got none either. So agenda item 14 is date, time, place of next meeting. So the next meeting is going to be on the 3rd of October.
Sorry, Chair.
Justin, yes.
Just in terms of any other business, very quickly, the personal injury discount rate has been amended from in the north from -1.5% to 0.5%. I'd like to commend the work of this committee. I think that might have an influence in terms of the government department actually setting that rate, which is influenced by the Department for Justice and the Minister, even though that was denied previously. So the personal injury discount rate has been moved to 0.5% positive. And I'd like a briefing in terms of to the committee to say what the implications are of that amendments to insurance premiums.
Justin, I'm actually wondering, we have the briefing, the joint briefing for us and the Committee for Economy with the insurance people on the 15th of October at lunchtime, and actually they might be, can we hear, before we seek that from the department, can we speak to them and see how they envisage it will impact on insurance premiums? And then it means whenever we've got information from that, we can be going to the departments, I suppose, with more comprehensive questions and overviews. Would that be all right?
Okay.
I think that's maybe means we can approach it in a more holistic way. Is that all right? Great, thank you. Okay, so the next meeting, because of the things we have to do, we're proposing to schedule the meeting for 1:30. Appreciate that's, I know that's far from ideal when you've all got committees in advance, but we're going to have something a bit more substantial for you to eat. Look, the aim about this, we need to consider the committee approach to the bill. We also need to hear from legal services, and then we've got effective questioning. The other thing around effective questioning is this. I know that you're going through this in your other committees, but I'd really love you to come to the one that we're going to have, and the reason is this. We've got a massive bill in front of us, and I suppose in terms of how we operate, there are going to be things on which we disagree, but thus far the committee's been really collaborative. So I think disagreement will be done in the nicest possible way and in the most constructive way, but there are also things where we're going to need to tag together in terms of questioning for areas of interest, and I think for us to build a team to maximise our time and our answers, things like how we deal with vulnerable witnesses who are maybe coming forward on the DNA retention over legacy cases and so on. That's what this training is going to incorporate. So it's going to have a different slant than what you've already been to. It'll be more tailored to what we need.
Right. Kira and I'll keep you right.
Happy days. So, but it's just, look, I think it'll be helpful for us as kind of team justice committee going forward to be able to work on that together. So thank you for that, and hopefully then we will see you next week at 1:30. Thanks very much, everybody. Thanks.
In here, isn't it?
Yes.
Okay.
Committee Room 30, sound. 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 Committee Room 30, sound.